Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Happy Monday. Happy Monday, everyone. Today is Monday, September 15th, 2025. And September is halfway over. When did that happen? I don't know, but it's going to be 80 degrees here in New York. So at least we got that going for us. How's everybody doing today? Good morning. Good morning. We had so much fun on Friday night at the Turtle Boy and Auntie Deb live show in Boston at the Wilbur. If you were there, I think you liked it. If you weren't there, I did a recap on Saturday night. And it was electric. It was electric. It was on fire. It was fantastic. It was sold out. It was at the Wilbur Theater in Boston. I was there. Nurse Kim was there. The Glare was there. Mark Betterow. Emily C. did a bit as John DePietro. Is that how you pronounce his name? John DePietro. It was awesome. You guys were so much fun. And it was wild. It was a great time. It was sold out to the bone. It was packed in there. And it is my personal opinion that the Wilbur will be begging Turtle Boy to come back and do another show. And Auntie Deb was unreal. Unreal. It was so much fun. And so, if you didn't see my recap, Nurse Kim also did a recap. Jimmy did a recap. Aiden did a recap last night. That was really good. And so, I think based on public demand, there will have to be another show. And based on the fact that it completely sold out and they made tons of money on the bar bills, especially, the Wilbur would probably love to have him back. And so we'll keep you posted. People traveled from Ireland, Switzerland, Minnesota, from everywhere. If you went to the show on Friday night and you traveled from a long way, tell me in the chat where you came from. Because you guys are dedicated. And based on the energy of that room and the people who are so supportive of Aiden Carney, I don't think there's any way in hell he's ever going to be convicted of anything. My opinion. It's my opinion, and I'm sticking to it. So, couple things. The Josh Hubert trial is still going on. It's going to continue today. But something wild happened on Friday in court. As you know, there's no cameras in the courtroom. This is the guy, Josh Hubert, who is accused of kidnapping a 7-year-old girl from her grandfather's house at 2:30 in the morning back in August of 2017. Puts her in his car. This is in Worcester, Mass. Drives around Worcester for like an hour or so. The little girl says, she's 15 now, testified that at some point he came in the back seat, strangled her, raped her, put a bag over her head and a rope around her neck, and then drove to the I-290 overpass and threw her into Lake Quinsigamond. By the grace of God, she was able to swim 100 yards to shore and went to a house that had the light on and knocked on the door, and the woman answered the door and called the police, and she lived. Josh Hubert was her dad's best friend since they were in middle school. The story is terrifying. The little girl at the time was taken to the hospital. Her parents declined to do a grape kit. They allowed fingernail scrapings, and there is no forensic evidence linking Josh Hubert to the crime. Originally, he was charged with attempted murder and assault. And then in 2022, when the girl disclosed the grape to her cousin, the charges were upgraded to aggravated grape of a child. He's been out on bail since 2017 on $50,000 cash, and the trial has been ongoing. Court TV made a motion to televise the trial, and the judge in Worcester said no. So we have been relying on accounts of Bo, our chatter, who goes by Adam Lalley's resignation. She was in court one day last week. Aidan Carney had done stories on this in 2017 when it happened. Then I brought it back to his attention when I found out the trial was coming. And then he went to court on last Tuesday. And Mass Live is the only one, I think, reporting on this. Maybe there's some patch articles by now. I don't think any mainstream media has picked it up. So what we learned during the course of the trial is that there was DNA found on the girl's underwear. Seminal DNA. Does not match the guy, Josh Hubert, the defendant, but does match the father. The father got on the stand and made an excuse that we all share a hamper in the bathroom, or did at the time. He's not married to the mom anymore. They're divorced since, or they separated. They broke up in 2020. She discloses in 2022. They say they share a hamper. The clothes the sperm could have gotten her underwear through the hamper. The father then testified that he did things in the bathroom that could have caused the seminal DNA to get on his daughter's underwear, like pleasuring himself and having relations with his wife in the bathroom. But on cross, the defense attorney said, wait a second, wasn't your hamper in the hallway? And apparently it was. And on Friday, it came out in court that there was a third contributor to the seminal DNA on the girl's underwear. A third contributor. Oh, also what happened last week, it came out on end of day Tuesday. Trial started Monday. End of day Tuesday, the prosecution, the Commonwealth, turned over to the defense a bunch of cell tower data showing that it's exculpatory because it shows that Josh Hubert was not in the area of the Worcester Bridge when this crime happened. It was just turned over on Tuesday. They've had it since 2017. They were rushed into chambers. Court was cut short for the day. And there was no trial on Wednesday because of this issue. And the defense attorney's like, what the hell am I going to do with this? I've been screaming into the abyss since 2017. My client didn't do it. And now you said you had all this video, all the surveillance video. You don't have that. And now you're giving me cell tower data showing that my client was not in the area at the time. This is crazy. Here's what Mass Live said about the third contributor of the DNA, because this only came out on Friday. And it says, the list of people tested for DNA to match sperm found on the 7-year-old victim's underwear after she was thrown from a Worcester Bridge in 2017 includes not just the child's father and the defendant, Joshua Hubert, meaning they were tested, but a third man not previously mentioned in the trial. So they tested 3 men. They got samples from 3 men, the father, the defendant, and one other man. to test against the DNA that was found. And it says his name surfaced on the 6th day of Hubert's trial on Friday when Judge Karen Bell, it's Karen with an I, Bell, gave the Worcester Superior Court jurors a set of stipulations after their lunch break. Stipulations are things that both sides agree on that the jury is to accept as true. Earlier in the week, the jury was told by prosecutors that there is no forensic evidence linking Hubert, who is now 43, to the charges of rape, attempted murder, and kidnapping related to the incident in 2017. Hubert is on trial for assaulting the girl from her grandparents' home in the middle of the night, kidnapping her from their house, assaulting her, and then throwing her off the overpass in Worcester into the Lake Quinsigamond. However, sperm cells found in the girl's underwear were identified as belonging to her father. He does not face any charges in connection with the incident, and he gave several explanations about how it could have gotten there, like we just discussed. According to Hubert's attorney, Kevin Larson, the third man who was tested, whose name was revealed in court on Friday, but who Mass Live is not naming because he has not been charged, also had some type of involvement the night of the crime. A woman who found the child that night in 2017 and called 911, Maeve Gary, had actually made another call before she called the police, Larson said, and it was to that third man. Okay, what? The girl knocks on the door of this woman, Maeve. Maeve made a call to this third man before she called the police. What did the girl say? You should call this person. I don't know. I have no idea. This is bad. Okay. No additional information was given by the judge or prosecutors on the man's identity other than he voluntarily gave his DNA sample on December 14th, 2017 to the Worcester Police Department, Bell told the jury. This sample was then sent to the MSP crime lab, and a DNA profile was created from his sample. Then there was a state police forensic scientist who testified on Friday that she tested the DNA samples of Hubert, the girl's father, and the third man, and that it was the girl's father who came back as a match. Okay, so I'm sorry, he did not come back as a match, this third man, but he was tested. Why? Why was there a third man tested? I have so many questions about this case. The Worcester County District Attorney's Office declined to comment on the third man. Kevin Larson, the defense attorney, shared his frustrations outside the courtroom on Friday. What are we doing here? I don't know. He said, that's why I said in my opening statement that I've been screaming into the abyss for 8 years. Everything that comes up points to Joshua Hubert's innocence. The trial is expected to wrap up at the beginning of this week, Bell told the jury on Friday, and closing statements are expected from both sides before she allows the jury to begin deliberations. If you're in Worcester and you want to go to this trial and you want to be boots on the ground, please do it. I have ordered the court recording from Friday. I'm hoping that they'll send it to me. And if they do, we can listen to it because I have a lot of questions. It's wild, right? Exactly. How is all of this coming out at the end of a trial, Brian? I don't know. It's insane. Stephanie became a new member, but Stephanie Sweedler, you've been here for an eternity. So I know you probably just renewed. Kristen, thank you very much. Kristen, for being with me for 16 months. Back to the land of the lost. Chaka is necessary. Betsy, happy Monday. I love you with all of my heart. Thank you for your super chat. And Jamie became a new member. Welcome, Jamie. I think you're going to like it here. This is where we shine a light on everything that, not just the state of Massachusetts, but so many other states like Arkansas don't want us to know about the Aaron Spencer case or anything else. I have so many questions, and I don't think they're going to be answered today. But hopefully somebody's in court today to keep us up to date, and hopefully we can get the court recording from Friday. And Stephanie Sweedler says Anybody who thinks a young child cannot be manipulated into telling absolute stories should look at the McMartin daycare case. Yeah, but here's the thing, Stephanie. As soon as the girl like swam to shore, she told this woman and the police that came to the scene that it was her friend Josh that threw her off the bridge. So both things could be true, right? Her father could have essayed her, and Josh could have been the one to throw her off the bridge. It could be. So I don't know. I just have so many questions. Oh, Bo said she's trying to get there by 1 today. We'll see. We can see you, Christina. We can see you. We solved your issue. YouTube has been acting really wonky lately, and it's like been blocking people like sua sponte, and it's really weird. If it happened to you and you weren't a jerk to get yourself blocked, Purple Kool-Aid man, because I see you. He said I have too many rules. He doesn't like all my rules. I'm like, the rules are simple. Don't be a jerk. Don't be a jerk. It's very easy to get in here and be nice in the chat. But if you come in here disparaging other creators, disparaging other people, you know, trying to dox other people, trashing me, trashing other people, I'm not going to tolerate it. The freedom of speech of the U.S. Constitution is not guaranteed in my chat. That is the right that the universe gives you. I mean, the universe. The federal government gives you. That is not stuff here. Yeah, and here we are, 7 years later. Right. David Cage, snark is encouraged, but don't be a dick. It's not hard. I mean, for some people, I guess it is hard. So there's that. See, look at Dave Matthews' neighbor. And he really is Dave Matthews' neighbor. Look, I got my fire dancing earrings on today. I met a girl at the Wilbur. She had a 41 tattoo. She found me. She came up to me. She showed us me. We bonded. He says, I didn't even know Melanie had rules. So there you go. Exactly. All you got, just be nice. All right. Well, in the true land of the lost Narnia upside down, inside out, that is Norfolk County, Massachusetts, we have learned that Robert Cosgrove, good morning, Kelly Yelly 68, good morning, and thanks for becoming a member. That Robert Cosgrove is apparently trying to indict Karen Read on some new charges. He filed a motion, or tried to file a motion, or allegedly filed a motion, or purported to file a motion back on August 28th. That is just kind of coming to light because Karen's new attorney, Steve Buzang, made a motion to get her phones and her Lexus back. And it was granted, apparently. And apparently the Lexus is at a body shop. Let me show you that video. I have a video on that. But the phones haven't been returned. And now Cosgrove has made a motion for a taint team to examine her phones that were seized in January of 2024. Remember? Karen's phones were seized again in January of 2024 because who was the prosecutor at the time? I guess it was Brennan or Cosgrove or Mello. I don't know. Tried to convince a grand jury to indict Karen and Aiden together on conspiracy to commit witness intimidation charges. And what had happened was the grand jury didn't, and Karen's team didn't even know about it until like the middle of trial number 1. And now it looks like Cosgrove is trying to do it again. Thanks, Altman. Oh, Altman, it was so good to see you on Friday night, my queen. She says it was Lally, but they were seized by Mello. Okay, so Lally is the one who took it to the grand jury, because I have so many questions about this, and I'm glad you're here because maybe you can answer them. Oh, and look, Scott changed his name to LawTube's most hated mod. What? That is you, Scott, right? Karen has a target on her back, plain and simple, and she has to do what she has to do to stay under the radar. Agreed. They need to leave Karen alone at this point. Let's take a look. I wanted to show you this video about the Lexus because this popped up on my feed the other day. So let's look at that one first. About 3 minutes long. This is from 4 days ago, September 10th. And we'll watch this before we go to the motion.
Now on Just One Station, we're getting an inside look at Karen Reed's SUV. State police took it apart during their investigation. So the SUV is now being repaired.
One of Reed's attorneys telling 7 News there's other evidence that hasn't been returned to her yet. 7's Jonathan Hall has the story you will see on Just One Station.
Karen Reed has not had the use of her Lexus SUV since that fateful night in late January of 2022. Now that's about to change. A rare look inside Karen Reed's 2021 Lexus, which was at the very center of the 2 murder trials the world witnessed. The car released by the state police and towed to this auto repair shop in Weymouth on Monday. A right rear taillight had...
All right, shout out to this repair shop in Weymouth that is apparently doing the repairs for free.
Has already been delivered to the shop and installed.
Put your blinker on. In reverse. All right, we're good.
JB Auto Care in Weymouth, shout out.
The original light was displayed for the first jury by Trooper Michael Proctor last year. He was fired for misconduct. These photos show damage to the front dashboard, which has 3 gaping holes.
Look at if you're not near your screen and you're not on scaffolding or driving an 18-wheeler down a highway or any vehicle, come look at your screen. Look at the inside of her dashboard. It's trash. This car, it's trashed.
The bottom section, where you see the electronic wiring, is where the radio and infotainment system was removed. The electronics between the front seats were also damaged.
It's like a phone module that was taken apart. Some chips were taken out of it. That's not salvageable anymore. So that's the part we're waiting for to see if the navigation system will work again.
During the trial, jurors heard expert witnesses testify about data taken from the car's computers.
There's actually many, depending on the vehicle, there could be hundreds.
And investigators say they had to
Oh, Shannon with one N. Elaine Burris, pointing out the obvious, love you, Elaine, says, I would never drive that car. No telling what they have hidden in there. Mm-hmm. And remember, the jury was taken to see the car twice. Twice during both persecutions. Once during each persecution when they went on their field trip, they also got a chance to look inside the Lexus.
Damage the Lexus to extract the airbag and infotainment system data.
2 photographs during the disassembly process of taking that module apart.
The owner here at the shop hopes to have his work done within a week.
Well, it's going to cost her nothing. It's probably going to cost me a couple $1,000s, but I'm more than happy to do it.
One of Reed's lawyers says
he's doing it. He's paying for it. He's fronting the costs for her. Isn't that nice? It's going to cost him a couple of $1,000s. What's he going to get out of it except for some goodwill? That's why I'm here shouting out JB Auto Repair in Weymouth.
the defendant, who was only convicted of drunk driving, is released.
It's going to cost her nothing. It's probably going to cost me a couple $1,000s, but I'm more than happy to do it.
One of Reed's lawyers says the defendant, who was only convicted of drunk driving, is relieved to get some of her property back.
I think very thrilled and excited to just have one more piece put to rest.
But Reed is still missing 2 cell phones. Her lawyer says they're not being returned because the Norfolk County DA is investigating her for intimidating witnesses in the case. Steve Buzang says,
Again? We're going to do this again? You tried and failed. What makes you think you have more evidence? Maybe that's why they want to keep her phones. I have so many questions, which we will go over while we read this purported motion.
The DA brought the case before a grand jury but failed to get an indictment. He believes prosecutors are planning to try with a different grand jury.
The facts are not there. So I don't know why they want to go back. I'm not sure. But we'll fight it out in court.
A spokesman for the DA's office says he cannot comment on pending investigations. As for whether Karen Reed might sell her vehicle, perhaps at auction, there's no word on that yet. Steve Buzang says she is considering her options. In Weymouth, I'm Jonathan Hall, 7 News.
So there's that. I don't know if Karen knows that guy, has a relationship with that guy. Lexus should gift her a new car just because they can. They should. That would be such a nice gesture of good faith, would they? I don't know. They can afford to. But also, she could auction the car off for a lot of money. People are saying the car was leased. I'm sure that lease is over by now. I mean, she must have had to buy it out. And so I don't know. I don't know if it was a lease. I don't know if she had to buy it out. I don't know if she had to extend the lease and keep paying. But he's going to fix it. She could probably auction it off for a lot of money as memorabilia. I think they auctioned off OJ's Bronco, or they were going to, or they did once, and they're going to do it again. And it's expected to raise like $1.5 million. I don't know. Could be. Oh, Howie set it up for her. Howie Carr. Shout out to Howie Carr. It's nice of him. She can have a garage sale. She can have a garage sale. Espresso and Saxa Peppa. And look at Lola 72, Lala 72 coming in and saying, JB Auto Repair is solid. Is your profile picture you and Kevy Kev? Oh, I love that. I love that. I got to meet the three of them on Friday night, JFK, James Jackson, and Kevy Kev in person. And wow, the vibe, the aura was amazing. They did like a red carpet show outside the Wilbur. And so many of you were there and answered questions for them. And they did like a man on the street thing. And they're like, if you had one word to describe Eden Carney, what would you say? And then James Jackson said such nice things about me on their show that I played the other night. And it was really, 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 really nice. It was really nice. Olivia says it was a lease. She had to pay payments on throughout her persecutions. Right. But like January 20th, usually a lease is like 36 months, right? So the lease must be over by now. So I just don't know if it's going back to the leasing company. I just don't have any info on that. And so I don't want to, I don't like to give out wrong information or misinformation, or, I just don't know what's going to happen to it. But there's that. Look at Badass Bianch wants to buy it. James was so sweet. He's got like the best skin. We need to know his skincare routine. Maybe we should have him on and do like a skincare routine show. You can extend your lease. Yeah, you can keep paying. You can keep paying and extend it. So I just don't know the actual real status of it. So there's that. The other thing that I wanted to show you, we can go over this later. There's Alan Jackson footage from the Fraser Bohm appearance last week. Brian Walshe was stabbed in jail the other night. There's a 2 p.m. hearing in front of Judge Krupp today at 2. We're going to cover it. Brian Walshe, Miles King, and all of the other defendants that are still trying to get Proctor's communications. But this happened on, I think it was either Thursday night, the 11th, or I think it was Thursday night, the 11th. Brian Walshe was stabbed in jail. Listen to this. But we are going to cover that hearing at 2 o'clock. That'll be a different stream. We'll teleport over there after this.
Before a Cohasset man's murder trial, someone stabs Brian Walshe in the head while he is in custody. That stabbing happened just before 10 o'clock last night in a housing unit at the Norfolk County Jail. The 48-year-old Brian Walshe suffered a non-life-threatening stab wound. Walshe is being held in the Dedham jail without bail. He is accused of the murder and dismemberment of his wife, Anna. He's also indicted on misleading a police investigation. Anna's body has never been found. Listen to the call to first responders.
Norfolk County House of Correction for a stab victim. Body was stabbed in the head, conscious and alert. Engine 4 to Coastal Unit 200 West, Norfolk County House of Correction. Body was stabbed in the head.
Walshe was transported from the dead.
How was he stabbed in the head in housing? Hi, Emily C. I love Emily C. I got to meet Emily C. too in person. We hugged it out. Will Lantley finally finish testifying? That's not even what this hearing is on for today. It's on for a status conference. Remember, they started that hearing and then they just aborted the mission because it was getting to a point where Lally was going to have to really start talking about some stuff and why he didn't like turn it over.
Jail and then treated at Beth Israel Deaconess Medical Center in Boston. He is back in the jail tonight. His murder trial is scheduled for October 20th.
People have theories about this whole Brian Walshe thing. And one of the theories is that Anna Walshe was some sort of Russian spy, because there was that whole spy thing that happened in Washington, D.C. at the building that she was monitoring or managing or something, and that perhaps she has been whisked to another country. Remember, she's got dual citizenship with Serbia, and that she may surface at some point. There's no body in that case. And maybe they made a deal with him like, dude, you screwed this up by getting arrested on your fake Andy Warhol stuff. And so you're going to take the rap for this. And then maybe 5 years from now, we will surface a video of Anna alive and well in the old country, and you'll be set free. This is what I've heard from someone very, very credible. And I wonder if that will come out at trial. That they both may have been involved in this sort of, it's just the Dyson Airwrap. Thanks for the hair compliments. It's the Dyson Airwrap. T. Evans says, I don't think she would leave her children. Well, listen, anybody watch The Americans? Like, spies do what they got to do, you know? So I don't know. If they found DNA on the hacksaw, you know what they could have done? Chopped off a finger. Listen, when you're involved with the wrong people, you're involved with the wrong people. They don't have any qualms about chopping off a finger and mailing it to warn somebody, or doing a little of this on the hacksaw, and then making some dumbass Google searches. I'm just saying. That's what I heard. And it's not that far out there. So I don't know. It was some sort of blunt shank that he got stabbed with in the head. Dude, JD, do you know about the what was going on in Washington, D.C. in her building? Look it up. It was rented out to some guys who like pretended they were with the FBI or CIA. Like there was a huge side story to this. And she did leave her kids quite a bit. Yeah. Yeah, right. Andrew, you need a tow? I can get you a tow. Did anybody watch the third season of You? When Joel Goldberg cut off his toe and set his house on fire? I mean, you know, you do what you got to do. But I'm just saying. It had to be a spork. Yeah, it could have been a spork. I don't know. But apparently his injuries were not that severe. And so, so he got let out. But still, I want to know who did the stabbing. Listen, these people want to get you. They can get you anywhere. You know that. Anybody watch the show? The one that took place on the Cape, Hightown. That was a great show. I'm so sad it got canceled. I loved that show. So much. And then this is the story that we are going to cover today. This was a piece that aired a couple days ago on WCVB. When was this? 1 day ago. September 12th. What did I say today was? The 15th. Oh, this must be, I must have pulled it up a couple days ago. Okay. So this is a piece from Friday regarding the phones and the motion that we're going to go over right now.
So it looks as if prosecutors might be trying to charge Karen Reed again. Reed has already been found not guilty of murder and manslaughter for the death of John O'Keefe, but new court filings show she is still being investigated for possible witness intimidation. David Bienick has been covering this case from the beginning. He's live once again outside the courthouse in Dedham this afternoon. David, good afternoon.
Hey, Ben, good afternoon. Yes, this new motion comes from a special prosecutor who apparently is trying to get access to data on two of Karen Reed's cell phones. Now, these are phones that were seized by state police 2 years ago, nearly 2 years ago. They were investigating Reed at the time for possible witness intimidation in connection to her murder case and the blogger known as Turtle Boy. Well, apparently, the police have not been able to get access to the data on those phones because in a motion filed late last month, Special Prosecutor Robert Cosgrove asked the judge to order Reed to turn over her passwords for the phone. And
I don't think that was covered in a hearing, was it? Because we watched all the hearings. If they didn't have the passwords to her phone in 2024 when they seized them, What did they show the grand jury? What evidence did they give the grand jury to try and indict her? If they didn't have access to her phone, were they relying on only Aiden's phones? Because we know that they lied about not extracting Aiden's phones without a warrant, because that showed up during the Michelle Littlefield debacle, because they attached something to, I think, Michelle Littlefield's termination that indicated that they had gone through Aiden's phones when they said that they hadn't, and they hadn't had a warrant and they couldn't get in. They lied. We know they lie. So, well, thank you, Elaine, for your very generous Monday. I'm very generous Venmo. And she says, just another manic Monday. These people make me sick. I appreciate you so much. Thank you. I think we are all sickened by this. We're all sickened by this.
To assign an independent team to sort through her emails and text messages.
Let's take that back a sec.
Special Prosecutor Robert Cosgrove asked the judge to order Reed to turn over her passwords for the phone.
Oh, in a motion,
and to assign an independent team to sort through her emails and text messages.
To me, it seems like a fishing expedition that shouldn't be taking place. She should have her phones back, and it should just be ended. Everybody needs to move on.
Now, a grand jury has already declined to indict Reed on witness intimidation charges, a previous grand jury, but nothing prevents the prosecutors from trying again with a new grand jury. Reed's lawyer says he does expect the judge to hold a hearing on this question before deciding whether or not to order Reed to give up her cell phone data. In Dedham, David Bieniek, WCVB News Center 5.
Oh, I know. Let's get another grand jury and we'll stack it this time and we'll see what we can come up with this time. Love being a Mimi, the insanity of doing the same thing, expecting different results. Yep. Happy Monday, Mama She. Love you. Love you. Thanks for being here for 13 months. Desert Cat became a new member. Welcome, Cosmic Blue. Come on, peeps, hit the like. Love you, Mel. Love you too. PJ Wolf just coming in here with a smile. Good morning, Brit Happens. Thanks for your 5. If she was in a blanket, how does she know it was Josh? Well, because he picked her up off the recliner, and she woke up thinking it was her grandfather moving her into the other room onto the air mattress, and she looked up and it was Josh. And she knows it was Josh. She's known him since she was born. Josh is black. Her father is white. That's how. And then he wrapped her in a blanket and put her in the back seat. The blanket wasn't like covering her head or anything. And she had conversations with him. And he said at one point, he told her that he was going to drive her. This is Josh Hubert. He told her he was going to drive her home. And then she noticed they weren't going near home. And he's like, oops, I guess I got lost. Great question, though. Altman became a new member. Welcome, Altman. Kay Willis, good morning. On my way to a listing apartment in Canton. Kay Willis is a realtor. If you need her and you're looking for a place in Canton or want to sell, call her. Gavel and Gloss, watch season 1 with you. Nobody wants season 3. Right. Nobody wants these. These are going to be new charges. Somebody said, what about double jeopardy? These would be new charges. These would be new charges of conspiracy to commit witness intimidation or just straight up witness intimidation. And so double jeopardy would not attach because they would be completely new charges. HFNF623, why didn't you cover the Proctor hearings? I don't know. I think it was like 2 or 3 full days. I covered them. I didn't cover them live because I was covering another case live at the time. And I just can't cover everything, but we did summarize them and we did go over them at length. I don't know if that was snarky or if that was like a genuinely nice question. I have no idea. Can't do it all. It's just me. Jen and Toxic, thanks for being a member for 3 months. Your dress was so cute. Looked amazing. Thank you very much. Deborah said he had to be stabbed with a spork or something. Really? Really? They just let him out. There were no stitches. So I don't know. But I did hear somewhere that it was like a dull shank. So that was the weapon. Did he do it to himself? I have no idea. Andrea, at what point does the federal government intervene in Massachusetts judicial system repeatedly stripping people of their rights? They don't usually interfere with states, states, federal separation of powers and things and stuff. And the FBI could still be investigating and they may step in at some point, but this is what they do in Massachusetts. They really, 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 really want to get Karen Read on something so it doesn't look like a total loss for them. I mean, as if the DUI conviction wasn't enough. They really, really want to do something because they're so far deep into this. And once all of this stuff is unimpounded on Aiden's case, all these text messages, emails, and other things, a lot of people have a lot of things to worry about with regard to their own incarceration, as that judge said the other day, Kathleen McCarthy Naiman. Remember her name. She's the judge on Kelsey Fitzsimmons. Thank you for your insight that you deliver with such wit and class. Thank you, Andrea. I appreciate you. Amy Jones says, I didn't know we were using vacuum cleaners to style our hair. I just learned so much over here. Dyson has a whole line of hair care products. They just don't do vacuums anymore. So yeah, it's a thing. See how much you learn? All kinds of things and stuff. And BB says, this explains, in my opinion, why poor Karen has been quiet besides PTSD. Great point. OMG, when will this end? I wish I was a fly on the wall when AJ heard this. PS, thank you so much for your compliment, BB. And BB, love you. And your super chat. Greg says, Karen Read, how is this not malicious prosecution? We'll see. They must think they have something, but I have so many questions. Let's look at the papers and we'll talk more. Mike B from the 413. Are they required to tell the new grand jury about the old grand jury? No. The grand jury proceedings are secret. There's no judge involved. It's just the prosecutor and their witnesses. They present whatever evidence they want. They're in complete and total control over it. And so they can pretty much do whatever the hell they want to do. And the only time a defendant finds out about a grand jury proceeding is when the transcript is turned over, or it's supposed to be turned over during automatic discovery in a criminal case, if there is an indictment. So I would love to know if any of the attorneys, like Bradel and Betterow in Aiden's case, or any of Karen's attorneys, including her current attorney, have the grand jury transcript from that grand jury that did not indict them. That is one of my questions, because if they didn't have her cell phone extraction, what evidence did they use to present to the grand jury to try and show charges of witness intimidation or conspiracy to commit witness intimidation? So no, they don't have to tell them anything. They can do whatever the hell they want. And that's that. Kristen said they had Karen's phone download for the grand jury. They also had all of the communication with Turtle Boy. So then what are they doing? Here's the papers. Let's take a look. Cosgrove's filings, as you know, give me a headache in general, but this one specifically is headache inducing for any of my practicing attorneys in Massachusetts or anywhere throughout the land. Any paralegals. I know we have a lot of paralegals in the chat. I don't know what this is or what this even purports to be, because the case number that this is filed under, 2482 SW 0004, does not exist in the mass courts system. This is a search warrant number. This is the number for the search warrant to which he is referring. I can't find it in mass courts. If anyone can find it in mass courts, let me know. This was served apparently on her attorney on August 28th. Hi, frankly, my dear. So I don't know where, if anywhere, this was filed. The motion by Steve Buzang to get back Karen's car and phones was filed under the Karen Read case in Norfolk Superior. Judge Canoti granted it. This, whatever this is, this motion, he's calling it a motion, was not filed under the Karen Read case number. It's filed under this case number, 2482 SW 0004, which does not show up. I even tried it with an extra 00004, because that's usually how their case numbers go. But it's not there. If anybody can find it, let me know, because I can't find it. This was also filed by Cosgrove prior to being sued by Lindsay Gattani, which gives him a clear conflict. And so it's crazy. I'd also like to know when Cosgrove was hired to be the special prosecutor for Karen Reed. Oh, thanks, big old dog. Emailed you link to Buzang interview on Howie. He said that he has read this transcript. The transcripts from the March 2024 grand jury. That's awesome. Thank you. I mean, I'm anxious to see his response to this. I would love for someone to do a FOIA request for all of Cosgrove's contracts with the Commonwealth. Was he hired to be a special prosecutor for Karen Reed? Because last I checked, it was Hank Brennan, but he's gone now. He cashed his check cleared, and he's split. So what gives him the duty or even the authority to make this motion against Karen Reed? I have no idea. He is the special prosecutor, or at least he's the stand-in special prosecutor for Aidan Carney, because Ken Mello has been MIA with alleged health issues. And we haven't seen him in quite some time. I keep asking for proof of life, but I think he is alive and he may have health issues. But Karen Reed is a totally different prosecution. So was Cosgrove hired to prosecute her? Because I'd love to see that contract. It's crazy. So this is just, there's no caption here. It's just in Ray 2482SW0004, Commonwealth's motion for examination of digital materials seized from Karen Reed pursuant to a search warrant issued on January 22nd, 2024. That's how long they've had the phones. On January 22nd, 2024, the Commonwealth sought in this court a search warrant for, quote, any mobile device capable of communicating and cell phones used by Karen Reed. The search warrant application was supported by an affidavit from, guess who? Detective Lieutenant Brian Tully. After review, the requested warrant was issued by Judge Krupp. Pursuant to the warrant, the devices could be seized and any data copied, quote, provided no search of that data will be done absent further warrant or order of this court. End quote. The restriction on copying was consistent with the affiant's representation in paragraph 101 that no search would commence until such time a taint team or special master protocol is agreed upon by prosecuting attorneys for the Commonwealth and defense counsel. Okay, so are you telling me that you never got a taint team to look at Karen's phones that you seized 2.5 years ago? No, AJ was well on her case before. Oh, you mean why he joined her civil case? This has nothing to do with the civil case. AJ joined the team for the civil wrongful death case. Right, Scott. So when Aidan was in jail, they took Karen's phones once again, and another kangaroo court grand jury returned no bill for the conspiracy to intimidate witnesses. Right. So reminder that Aidan Carney was in jail from something like late December until February, late February, 60 days. And while he was in jail, was it Tully who went to Karen's house and pulled up in the driveway? Because I remember when this happened, or like reading text messages about when it happened. And she said, Tully's in my driveway. And he came in with a search warrant and he just took her phones. Marianne says, now I understand why Karen is laying low. Yeah, Massachusetts is crazy. It's exhausting. Imagine how it is for her. The search was executed on January 24th, 2024 at 14:45 hours by Lieutenant John Fanning, so it was Fanning? Was it Fanning and Tully that went to seize her phones? Who filed a return of service indicating seizure of 2 Apple iPhones, 1 purple with a green case, and 1 white with a clear case. The Commonwealth incorporates the warrant supporting affidavit and return by reference, footnote 1. which says, for the court's convenience, a copy of the warrant and supporting material is attached here too. Good, because we need to read this warrant. The supporting affidavit at paragraph 83. Oops. Asserted that the facts set forth therein provided probable cause to believe that Karen Reed committed a violation of Massachusetts General Laws 268-13B, witness interference. Paragraph 84 asserted that the facts further established probable cause to believe that Reed also violated General Law 274, Section 7, conspiracy to commit intimidation of a witness. Following the seizure of 2 cell phones pursuant to the warrant, Special Prosecutor Ken Mello, having been contacted by attorney Elizabeth Little, conferred with counsel representing Karen Reed in the then pending criminal case, concluded Ms. Reed is represented by attorney Stephen Buzang with respect to the seized cell phones. Wait a second. Following the seizure of 2 cell phones pursuant to the warrant, Special Prosecutors Ken Mello, okay, so that would have been in January 2024, having been contacted by Elizabeth Little, who was on the case at the time, conferred with counsel representing Karen Reed in the then pending criminal case, and then concluded is in, and this is when punctuation is so important. Is he saying that the then pending criminal case is now concluded, or that somebody concluded something like made a conclusion? There's no period there. It's a comma. Ms. Reed is represented by attorney Stephen Buzang with respect to the seized cell phones. Okay. Punctuation matters. Cosgrove. The purpose of this motion and memorandum is to set forth a proposed taint team protocol. In paragraph 102 of the supporting affidavit for the search warrant, Lieutenant Tully averred that once a protocol is agreed upon, I will apply for a subsequent search warrant to particularize the search. The Commonwealth will follow this procedure upon this court's approval of a protocol. So they're trying to tell us that they never searched her phones that they seized in January 2024. Do you believe that? Do you believe that? Because we know that in 2023, January, which would have been 1 year prior to this, they took Brian Walshe's cell phones and went completely outside the scope of the consent search without a warrant and downloaded and extracted his entire phone, including Google searches and location data. We also know that they lied about extracting Aidan Carney's phones. And then it came out through Michelle Littlefield that they had done it. And I don't know if Aidan ever got his phones back. They also returned Brian Walsh's phones to him, who's accused of, hacking up his wife and distributing her in dumpsters throughout town in garbage bags within less than 24 hours. I think it was 18 hours that they took his phone, extracted it, and then brought it back to him. Wild. This is a different phone seizure. This is not the seizure involving Proctor. Somebody said, I thought Proctor went through Karen's phone without a warrant when he was at Karen's parents' house. This is a totally different issue. These are different phones. That phone was seized in 2022 January. This is 2024 January. So they really, really, really wanted to not only get Aidan reincarcerated, but they wanted to put Karen Reed in jail so she would be there during her trial, which turned out to be trials. The seminal Massachusetts case approving a taint team protocol is preventive medicine. The precise question addressed by the Supreme Judicial Court in preventive medicine was whether the taint team procedure authorized in the specific order of the Superior Court under review by the SJC was permissible under the Massachusetts Constitution. In holding that it was, the SJC did not purport to say that taint team procedure was the only permissible means of protecting the attorney-client privilege, during a search of electronic documents. Ultimately, the question is whether the search procedure, whatever it may be, is reasonable. And then he cites some cases about the Fourth Amendment. A search to be reasonable must include reasonable steps designed to prevent a breach of the attorney-client privilege. Well, Hank Brennan didn't give two shakes of a rat's tail about attorney-client privilege. In a Norfolk Superior Court case, Commonwealth v. Richard Comenzo, the Commonwealth had seized an attorney's computer pursuant to a warrant to search for child porn. Oh, better get out my red pen and X that out. YouTube does not like that word. And the attorney claimed that his computer might contain privileged communications with clients. Although the case presented a different factual and procedural scenario than in preventive medicine, the Superior Court initially fashioned a taint team procedure closely following the preventive medicine model. In discharging his obligation to provide the taint examiner with search terms that would capture information subject to the attorney-client privilege, the defendant proposed that the search terms for potentially privileged files be limited to any files containing any letters A through Z or numbers 0 through 9. The investigation ground to a halt, the problem eventually coming to light in a hearing before another Superior Court judge who substantially modified the protocol in preventive medicine. The defendant filed a petition for relief, which a single justice of the Supreme Judicial Court denied. The defendant appealed to the full bench of the SJC and moved to stay the Superior Court order pending appeal. The SJC denied the motion, and the search proceeded, finding the sought evidence of child P. The defendant did not claim that any of the files found were protected by attorney-client privilege, and accordingly, the SJC dismissed his appeal as moot. Okay, that case seems to have nothing to do with this one, because they served, they seized an attorney's computer. Are we losing the plot here? Are we losing our collective minds? I think we might be. With these considerations in mind, the Commonwealth proposes the following taint team forensic search procedure for the search of communications and data located on the cell phones seized pursuant to the above entitled search warrant. 1. The taint team will consist of a special master and an appointed forensic examiner, AFE, who has not been and may not be involved in any way in the investigation or prosecution of the defendant presently or in the future. You may recognize these names. Stephen Verino of MWF Multimedia Forensic Investigative Services shall be the appointed forensic examiner. Retired District Court Judge Joseph Macy shall be the special master. The special master. These are the same two guys that they wanted on the taint team for Aidan Carney. Footnote 2. By agreement of the parties in order of this court, Mr. Verino serves as appointed forensic examiner and Judge Macy as special master in the pending case of Commonwealth versus Aidan Carney. Various electronic devices of Carney's, including cell phones, were seized pursuant to separate warrants as part of the same investigation that generated the warrant before this court pertaining to Ms. Reed. The AFE and the special master shall indicate their agreement to the conditions set forth by endorsing a copy of this court's order and filing it with the criminal clerk's office, Norfolk Superior Court, within 14 days of the date of this court's order appointing them. These individuals were specifically chosen because, number one, they have the expertise to search for and identify privileged communications. Number 2, they will be able to conduct this work physically and functionally separate from the Norfolk District Attorney's staff. The special prosecutors assigned to this case and any agents specifically assigned to this case 3, they have not been and may not be involved in any way in the investigation or prosecution of the defendant presently or in the future. Right. That's my question too. Should it be the same taint team as on a related case? Remember, they refused to allow Betterow pro hoc admission on the Karen Reed case because of his alleged conflict. Classy Clippy, that's a great idea. I mean, that's a great point. The special master shall have no formal or informal contact about this case with any police officer, forensic examiner, or ADA who has worked on this matter, except for the designated taint team, AFE, without prior court approval. The cost of the taint team will be borne by the Commonwealth. 3, within 14 days of the date of this court's order, counsel for Ms. Reed shall provide to the court search terms to facilitate the taint team's identification of attorney-client privileged information. Cricket says the phones are evidence in a separate and settled case. No, they're not. These phones were seized in January 2024, specifically for the purpose of trying to indict on conspiracy to intimidate witnesses or witness interference. That case has not proceeded because the grand jury failed to return a true bill. They failed to indict. So they don't need a new warrant because they already have the phones. See what I'm saying? So do not confuse this with the criminal case that has already been tried and she's been acquitted. That was for second-degree murder, vehicular manslaughter, drunk driving. The search terms shall consist of telephone numbers and email addresses of the defendant's attorney or attorneys believed to be used in attorney-client communications and the names of those attorneys. Footnote 3, which says the Commonwealth recognizes that in addition to communicating with counsel relative to the present cases, she may have had an attorney-client relationship with respect to other matters in which, of course, the Commonwealth has no interest. If so, the same identifying data, names, phone numbers, and email addresses may be supplied. Under no circumstances should there be search terms designed to screen out communications with Aidan Carney's attorneys, including, but not limited to, Timothy Bradel. Is he also talking about Betterow? Because he doesn't mention Betterow. Jan says, have you seen the company who they want to hire to go through Karen's phone? Marty Kraft belongs to the company. That's concerning. They named the company. It's AFW, I think. I don't know if that's his company or not. AFE. No, that's the forensic examiner. Wait, hold on. It's MWV, Multimedia Forensic Investigative Services, Inc. Is that Marty Kraft's company? I don't know. If anybody knows for real, let me know. The defendant, thank you, Jan, for your comment. That's a good one. What is Jess Machado being charged with? Jess Machado is not being charged with anything. Who said Jess Machado had charges? Daisy, who said Jess Machado has charges? I haven't heard anything about that. And we don't like to spread misinformation. Chat, you can tell people in the chat, Jedi Jen specifically, about who Marty Kraft is. Marty Kraft is the guy that Kate Peter worked for, right? He's a private investigator. It's also alleged that maybe Proctor was doing some work for him and Brian Albert, but I don't really know. I don't know all the lore on that. Marty Kraft. She's not. There's no charges for Jess Machado that I'm aware of. The defendant may supply additional search terms if necessary. If the defendant offers additional search terms, he shall file an affidavit affirming that the supplied terms are those reasonably necessary to identify and protect information protected by the attorney-client privilege. It appears to the Commonwealth that telephone numbers and email addresses are not confidential, but in the event the defendant harbors a good faith belief that disclosure of any search terms would compromise attorney-client confidentiality, he may submit such terms to the court under protective order without disclosing them to the Commonwealth, including therewith a statement of good cause for each such term. Rita says, yes, Mike Proctor was working for him. Clerk's apparent pain says Kraft is the sketchy former cop, now private investigator, contracted by the Commonwealth to do dirty stuff. And Karen Reed, Turtle Boy, other investigation, Kate Peters' boss. Thank you. Mama Rico 3 says Jessica Hyde does work with the company on the Tain team. Tracy says Marty Kraft from HR Puff and Stuff. Well done. Well done. I don't know about it. I don't know who threw the drink in Mark Bettero's face, but I don't know. Yeah, it happened, but I wasn't there and I didn't see it. And I really don't know what had happened. I think there was a couple of women that were fighting with each other and they threw a drink and it landed on him, but I don't really know. But yeah, I'm sure you can find that information somewhere else. I just don't know. I was somewhere else in the building. I was in the building. I did not see the incident. Actually, I think it happened at the Wilbur. It didn't happen at the casino. It happened at the Wilbur, or outside. I don't know. I don't know. Also, within 14 days of the date of this court's order, I mean, Cosgrove is very confident that he's going to get a court order, but he didn't even file it under any existing case number. So I'm not sure how it's even going to get to a judge. Counsel for Ms. Reed shall provide to the court any passwords or other information necessary to access the Seeds device. Yeah, I don't think that's how it goes. I don't think she's got to give up her passwords. I don't know. Is that like a Massachusetts thing? She's not been convicted of anything. She's innocent until proven guilty. I don't think that there's a requirement that she give up her passwords. I think you got gray key for that if the court orders it and allows it. But between you and me, I don't believe that they've never extracted her phones. Because what evidence did they have to present to the grand jury if they didn't? It's so bizarre. Right. Also, how do you remember passwords from years ago? I mean, a lot of people use the same passwords for everything. I'm assuming after they seized her first set of phones that she got a different phone number. I don't know for sure. But that would have been a smart thing to do because if she has an iPhone, she would have an iCloud and then all of that information would still be populating into the old phone too under the same phone number. So I don't know. I have questions. Says yes, they can force you to turn over numerical and alphabetical password if they have no court order in Massachusetts. I need a citation on that because I just don't know the answer for sure. Some people, I just need a latte, says, I don't remember my passwords from last week. And you can't turn over what you don't recall, says LawTube's most hated mod. If you don't recall your password, how can you turn it over? Right? Would they force her to come in and do like facial recognition on the phone? So messed up. Right. D. John says you're not obligated to help them with their investigation. Or alternatively, if she doesn't hand over her passwords, notify the court and the Commonwealth that he asserts a Fifth Amendment privilege not to disclose such information. No. Why should he have to assert the Fifth Amendment on her behalf against incrimination? If Ms. Reed claims a Fifth Amendment privilege, the Commonwealth may file a motion to compel him to provide the information sought under the holding of Commonwealth versus Gelfgat, 2014 case. The AFE may also attempt to access the devices without the assistance of passwords. After review of the search terms, the court shall transmit those that it approves to the AFE, noting that any must be kept confidential. The AFE shall not discuss them or disclose them to the Commonwealth without prior leave of the court. In the event the AFE does not receive the terms or has concerns about the terms, such as over or under inclusiveness, the AFE shall notify the special prosecutor so that the case is brought to the Norfolk Superior Court for hearing. Please, please do. We would love another hearing on this case. We would love it. And guess what? Judge Cannoni is no longer in Norfolk Superior. So who would be assigned to it? Would it be random? Would it be that wacky judge who allowed that hearing to go forward? Who was that judge? When Karen and her team were downstairs in the basement watching YouTube, and that's the only reason that they found out that there was a hearing upstairs with Bradel and Aiden and Brennan trying to get access to attorney-client privilege information, or Karen's text messages with Aiden or something like that. I don't remember. Was it Krupp who was on that hearing, or was it the other one? The AFE, number 4, the AFE shall search the phones for privileged communications using search terms provided by the defendant and share the results with the special master. The special master shall review any material identified as potentially privileged and determine whether it falls within the attorney-client privilege or whether it is unprivileged. This determination will follow the definition of privilege set out by the Supreme SJC, footnote 4. It wasn't Krupp. I don't think it was Pomerol, because I think Pomerol sits in district court, right? Sisitsky. Yay, Fairy Raven. Fairy Raven got it. It was Sisitsky. You are correct. You are correct. Fairy Raven watches all the way from Ireland, and I love her with all of my heart. No, they didn't find out because Turtle Boy was live streaming it because he was in court. I was live streaming it. They might have been watching me. Rumor has it. Footnote 4. The classic formulation of the attorney-client privilege is found in 8J Wigmore Evidence, the McNaughton Revised Edition. 1. Where legal advice of any kind is sought. 2. From a professional legal advisor in his capacity as such. 3. The communications relating to that purpose. 4. Made in confidence. 5. By the client. 6. Are at his instance permanently protected. 7. From disclosure by himself or by the legal advisor. 8. Except the protection be waived. Well, then they would not be able to get any communications with Betterow, because Betterow was planning to join her team and was thwarted by Judge Cannoni. The purpose of the privilege is to enable clients to make full disclosure to legal counsel of all relevant facts so that counsel may render fully informed legal advice with the goal of promoting broader public interests in the observance of law and the administration of justice. 5. The AFE and the special master will create a list of each item of data, i.e. letter, text, email, draft document collected by using the search terms, the potentially privileged list, which list for each such item shall 1. Identify the potentially privileged item through a description of the device on which the data was located and the physical sector range on the media at which the data is located. If necessary, additional methods of identifying the location of the data may be used, such as date and time, to adequately notify the Commonwealth as to the location of the privileged data, and 2, whether the special master concludes the communication is privileged. The AFE shall export the content of the potentially privileged list, place it in a sealed envelope, and provide it to Ms. Reed's counsel. 6, before any information is disclosed to the Commonwealth, Ms. Reed shall have 14 days from receipt of the potentially privileged list to file with the court any objections to the taint team's determinations. Such filing shall be subject to a protective order and subject to further order of the court shall not be reviewed or accessed by anyone other than the court and counsel for Ms. Reed, except that Ms. Reed shall serve the Commonwealth with a certificate of service indicating the filing of the objections. 7, final determination of issues of privilege shall be resolved by the court. If any objections are timely filed after the court considers and rules on defendant's objections, the AFE shall produce to the parties a list of all the data ruled as privileged by the court. B, if no objections are timely filed, the AFE shall produce to the parties a list of all the data identified by the special master as privileged. The list of privileged data will be provided to the special prosecutor so that the Commonwealth's examiner will exclude any data so identified from examination during the prosecution's examination of the seized media for evidence. Eight, if the Commonwealth, in examining the digital materials, discovers material or information not identified by the special master that it believes nonetheless, wait a second. If the Commonwealth, in examining the digital materials, discovers material or information not identified by the special master that it believes may nonetheless be subject to attorney-client privilege, oh, okay. So they might leave some stuff out, and then you, Cosgrove, because when was he appointed to be the special prosecutor for Karen Reed? Anybody? Anyone? Bueller? The special prosecutor shall notify Ms. Reed's attorney, and the Commonwealth agrees not to make derivative use of any such materials subject to attorney-client privilege. Yeah, because they've been so good about that before. The determination of privilege will be made by the court. Remember how they tried to get Karen's privileged communications with David Yannetti? Remember when that happened? Scott McGinnis coming in with the background. Robert Cosgrove was an ADA in Norfolk County before he was the next wrongly appointed judge by Massachusetts Governor Mitt Romney in 2006. Kazi knows Meatball, who has been in offices since 1997. Mrs. Parks is in the house and she's thrown down a $50 super chat. She says, if anyone believes that they have not already gone through her phones, I have a bridge in Brooklyn to sell you. Also, if you get that reference, you're probably due for a colonoscopy. I miss seeing you on Friday too. I know, I'm so sad that you couldn't make it. Thank you for the compliment. I love you. I appreciate you. It was so much fun. We did get to meet one time all the way back like a year ago. But it would have been so great to see you. But, kids come first, as always. And thank you so much for your super generous super chat. And Manj, I can't lie. This feels weird. Thank you for your super sticker. I appreciate you. Joy says, how can they get a new grand jury when the first one failed to indict? Don't they have to bring her up on new charges to go back to the grand jury? They are allowed to go back with another. They can try again with another grand jury. That's what her attorney said on that clip that I played earlier. I don't understand how they didn't have her phone extraction the first time in March of 2024, which is wild. Is he hoping that he's going to find something in this extraction now if he actually gets a taint team? I'm very confused too. You're not the only one that's confused, Joy. I'm confused too. Music to My Soul likewise says, so if a grand jury returns no true bill, prosecutors can keep trying to file the same charges until they get an indictment. That seems so wrong. I know, but again, We're in the inside out, upside down land of the lost. Massachusetts, ruled by Chaka, who is now up in your upper right-hand corner. From Land of the Lost, if you're a Gen Xer, you'll get the reference. Thank you for your super chat. Steve F says Betterow should not be showing any professional deference to this guy. He deserves none. Thank you, Steve, for your super chat. Mike B from the 413 says he is hired as special prosecutor for Aiden. Correct. Cosgrove. Well, not really, though. He's really just a stand-in, right? But Mello has now been DQ'd from being the special prosecutor on one of Aiden's cases. And now that Lindsay Gattani has sued or tried to or purported to sue Cosgrove, he's going to have to be DQ'd. So this whole thing is a mess. Mike says the Commonwealth is going to say it applies for anyone he can show was a co-conspirator, like Mello did when Janelle Webb was charged. Okay. Thanks, Mike B from the 413. The AFE and the special prosecutor may communicate in order to facilitate the process and arrange for the transfer of the evidence. However, they may not discuss the content of potentially privileged material. The AFE may not reveal any information considered or determined to be privileged to any member of the prosecution team. The AFE may be required to testify about the process. Any party may bring this case forward to the court to address any issues that arise in connection with the execution of the court's order. Conclusion. Wherefore, the Commonwealth moves that this court approve the protocol outlined above so that the Commonwealth may examine the media seized pursuant to the search warrant issued by this court. Yeah, he doesn't say it, but the search warrant was issued in 2024, January of 2024. Respectfully submitted, XOXO, Robert Cosgrove, Special District Attorney. And he says he served it on Steve Buzang on August 28th, 2025. Here's the Tully search warrant from 2024. This will be fun reading. Should we read it? Let me know if you think we should read it. Muzzy says, for heaven's sakes, when are they going to stop? Never. I think never. Thanks for being with me for 20 months. Libra in Seattle became a new member. Welcome. Honey Bear says, I'm glad YouTube didn't unsub me from you this month. Thanks for being with me for 9 months. And also, check and make sure you're still subscribed because YouTube has been doing that. They've been unsubscribing people, sua sponte. They've been blocking people, sua sponte. I do not allow it, but they don't care what I think. So make sure you are still subscribed. It's free. Just hit the subscribe button below. And if you're not, why aren't you? And you should have all notifications set too. I learned from my YouTube analytics. YouTube is owned by Google and gives you more analytics than you even know what to do with. But only 19% of you who are subscribed have your notifications set to all. So maybe that's why you're not getting them. And then you have to also make sure you have your notifications enabled on your phone from YouTube. So you got to do it right, or it won't give you the notifications. Simple reminder, friendly reminder. Anything Bev can do, Babs can do better. It says, love you, Melanie from Portsmouth, England. Thank you so much for being here for 6 months. Becky says that the Commonwealth need new evidence to go back to the grand jury. Well, we don't even know what evidence they tried to show the first time. I assumed they already had the phone extraction, but they're saying they didn't. Or maybe they did, but they didn't have a taint team. So now they want to make it look legit and do it the right way. Because we know how many times they've done it the wrong way, because we've seen it in a lot of cases, not just the Karen Reed case, not just the Aiden Carney case, but in other cases like Brian Walshe and others. For decades, in my opinion, the MSP and Norfolk County have just been doing whatever the hell they want. And nobody ever really looked closely enough at them. Warrant? Who needs a warrant? We'll get a warrant. We'll backdate it. Remember Fanning got up on the stand during the Brian Walshe evidentiary hearing in the motion to suppress the evidence coming from his cell phone and kid's iPad because it was outside the scope of the consent warrant. Fanning got up there and was questioned by Larry Tipton. We love him. Excellent public defender in the state of Massachusetts, represented Penny McGee and got Penny McGee acquitted on a bench trial in front of Judge Cannoni. We watched that together. It was fantastic. And Fanning got up on the stand and said under oath that he just made a police report or a chain of custody report or some report last week in 2025 and backdated it to January of 2023, because that's how they do things there. That's how they do it there. Thank you, Becky, for your super chat. Ms. Parks also says, how is Cosgrove not conflicted? This is bananas. Yes or yes. I don't even know how he's even making this motion. I don't know what standing he has to make it. I have no knowledge that he's been appointed special prosecutor for Karen Reed. That guy was Brennan, and he's gone. Cashed his checks and he left, and he's no longer on the case. So it is bananas. Yes, 100%. Thank you for your another super chat. And Music My Soul says they'll continue as long as Morrissey is in office. I agree, Emily C. Emily C says maybe YouTube's default should be all because WTF even is personalized notifications. I know. I was missing like a lot of people that I follow, and I'm like, oh, like Natalie, the lawyer chick. I'm like, where's Natalie? I haven't seen anything come up in my feed from Natalie in a long time. And it turned out that that's what had happened was it wasn't set to all. It was personalized, and I was getting 0. Hold on. Okay. Very Raven, yes, there is a transcript for the previous grand jury session. There must be one. Somebody indicated that her lawyer Buzang has it, I guess, or somebody has it. If they don't have it, they should get it. But there absolutely would be a transcript. They would just have to order a copy. Thank you, Fairy Raven. Excellent question, as always. Okay. I know, I hate that top messages. I hate top messages. It should automatically be set to all. I don't even know what top messages means. Like, how do they determine what a top message is? I hate that. All right. So here's the application for the search warrant that Brian Tully filled out all the way back in 2024. And he has to check off some little boxes. And this PDF won't let me highlight it, so I need my red pen. It says, based upon, he says, the undersigned applicant being duly sworn deposes and says that I have the following information based upon the attached affidavit consisting a total of 31 pages, which are incorporated herein by reference. Based on this information, there is probable cause to believe that the property described below is intended for use or has been used as the means of committing a crime and is evidence of a crime or is evidence of criminal activity. I am seeking the issuance of a warrant to search for the following property: any mobile devices capable of communicating and cell phones used by Karen Reed. And then it says, seizure only, no search of data as outlined in affidavit. The data on any cell phone seized may be copied, provided no search of that data will be done absent further warrant or order of this court. Do you think they searched it without a warrant or a further order of the court? And then it says here, there's another box that says, I have previously submitted the same application. Because remember, if I recall correctly, they tried to get the devices and then they couldn't. She was out of town or something. They couldn't get them. I forgot exactly. Right. So they have an extraction. They just haven't viewed the extraction. Well, they're saying all they did was seize them, that they didn't search them. allegedly, but it's confusing. This is repetitive. And then it says, the property is on the person or in the possession of Karen Reed. And then it says, you are not also authorized to conduct the search at any time during the night. You are not also authorized to enter the premises without announcement, and you are not also commanded to search any person present who may be found to have such property in his or her possession or under his or her control to whom such property may have been delivered. Yeah, I remember they pulled up in her driveway and she communicated with somebody, I forget who, and said, "Oh my God, they're in my drive. Tully's here. Tully's in my drive." It was Tully. I think it was Tully and Fanning, right? And knocked on her door and said, "We have a warrant to seize your phones." And I guess she gave them her phones. And that's issued 1/22/24, signed by Peter Krupp, Judge Krupp. Search warrant was issued on January 22nd, 2024, and I've executed it. And here's what I got. I got an Apple iPhone, purple with a green case, and an Apple iPhone, white with a clear case. The inventory was made in the presence of Lieutenant John Fanning, and there's Brian Tully signing off on that. 1/24/24 is when they seized the phones. 14:45 hours, which is 2:45 p.m. So I guess it was in the afternoon. Here's Brian Tully's affidavit. Stacey, no. She says, I think Hank got these already and they have looked at it, but can't bring it into aid and stuff because Karen has double jeopardy. No, these are totally different charges. Let's not get this confused. Karen has been charged with second-degree murder and the vehicular homicide charges and the drunk driving. She has never been indicted for witness intimidation. These are totally different charges, and double jeopardy does not apply. Does not apply here. And they're not looking to bring this into Aiden's case. They're looking to re-indict Karen Reed on new charges. New charges. Okay. Just to clarify. It's like they type this on an old-fashioned typewriter. It's like totally askew. It's not centered. Half of it's cut off. And it's 31 pages, so we may just skip around and skim it. I, Brian Tully, being duly sworn, depose and state that the following is true to the best of my knowledge. He says he's been with MSP since 2006. In 2012, he was assigned to the Norfolk State Police Detective Unit. He's investigated serious and violent crimes, including all kinds of things and stuff. In 2019, I was promoted to the rank of sergeant and supervised homicide and violent crime investigations. In November of 2021, I was promoted to the rank of detective lieutenant and appointed the unit commander of the Norfolk State Police Detective Unit. So that was right before the murder of John O'Keefe in January of 2022. He was new on the job. I've participated in all kinds of search warrants. I'm trained in criminal investigation, all kinds of things, death investigations, crime scene investigations. I've got all kinds of specialized training in evidence collection and processing. And I've received specialized training to obtain and analyze cell phone data and call data records in support of criminal investigation. I've testified as an expert witness regarding cell phone technology, forensics. And I'm a really, really trained and superior guy in all aspects of this stuff. I got a Master of Arts degree in criminology from the UMass Lowell and a Bachelor of Arts degree in criminal justice from Stonehill College. In addition to my assignment in the Division of Investigative Services, I have been assigned to the Division of Field Services working in Troop C. Somebody else in this case also went to Stonehill College. Remind me who it was. Classic Clippy. Aiden was in jail when this was happening. Aiden was in jail. Paul O'Keefe go to Stonehill? That's what it is. Thank you. I thought so. I was going to say this, but I wanted to get it right. Normal Mom and Shock and Horror says Paul and Tully played football there at Stonehill. He was on the football team with Tully. Paul O'Keefe was. Just when you thought you knew everything, if you didn't know that, there it is. Paul O'Keefe was the quarterback. Tully was the lineman, says Clerk's Apparent Pain. Crazy. It's crazy. Because you just can't make it up. You just can't. Based on my information contained herein, which are the product of my own investigation and my discussion with the Massachusetts state troopers involved in the investigation, I submit that I have probable cause to believe that evidence of a violation of General Law 268-13B, witness interference, and a violation of 274 Section 7, conspiracy, will be found on cell phones and or mobile digital devices used by Karen Reed. This application for search warrant is to seize devices only as described below. Let's look up the statute on witness interference, because this is not witness intimidation now. This is witness interference. (268-13B). Why is he saying? Because 13B doesn't say witness interference. That's the witness intimidation statute. Intimidation of witnesses, jurors, and persons for furnishing information with criminal proceedings. Here's 13B. You can Google it for yourself, but let me show it to you. Massachusetts General Law 268-13B says intimidation of witnesses, jurors, and persons furnishing information in connection with criminal proceedings. Interference, intimidation, same, but no, it's not. If you're going to write a search warrant, intimidation has a far different, in my opinion, legal definition than interference. But these are Tully's words on the search warrant application. And there's the statute. Whoever willfully, either directly or indirectly, threatens, attempts, or causes physical, emotional, or economic injury or property damage to A witness or potential witness, a person who was aware of information, records, documents. I think it was also, it doesn't also extend to family members of witnesses. Misleads, intimidates, or harasses another person who's a witness or potential witness person. Oh, look at this. Look at this. Whoever willfully, either directly or indirectly, I'm going off on a little side quest here, conveys a gift, offer, or promise of anything of value to, remember somebody offering Proctor a gift? To a police officer with the intent to, or with reckless disregard for the fact that it may impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, shall be punished by imprisonment in the state prison for not more than 10 years, or by imprisonment in the House of Corrections for not more. Why wasn't Julie Albert ever charged with this for offering Michael Proctor a gift as a thank you the day that Karen Reed was arraigned? When this is all over, tell your brother I want to get him a thank you gift to Courtney Proctor to Michael. Julie wants to get you a gift when it's all over. Proctor says, oh, tell her to get one for my wife. Any reason why she was never charged? Oh, could it be because her husband is a town select board member in Canton? Could it be that one of her brother-in-laws is Kevin Albert, who's with Canton PD? And could it be that another one of her brother-in-laws is Brian Albert, owner of the house at 34 Fairview? Interesting, right? This is what you call selective persecution. Prosecution, really, but I call it persecution. They have chosen to weaponize this exact statute against Aiden Carney to the tune of, I don't know how many charges are remaining, at least 10 felonies. He's facing 10 years times 10, over 100 years in prison on BS trumped up bogus charges because he didn't think John O'Keefe was hit by a car. And he was right. But then someone like Julie Albert can offer a gift to Michael Proctor, who's investigating the exact same homicide murder. Right? And what about Jen McCabe buying somebody a couch, maybe, for testimony against Aiden? Maybe, Elaine, exactly what I was thinking. Why are those people not being charged with anything, you say? The lead investigator, KBD, the lead investigator. And there should be Turtle Boy's article, next article right there. I don't know if he's already done one on it. To be honest, I haven't read all of his stuff, most of his stuff, because I've tried to just form my own opinions throughout this case. Why? 2 sets of rules, 2 sets of books, 2 sets, says Clerk's apparent plan. You are not free citizens. And Christina's getting mad. This is not okay. What's the statute of limitations on this witness intimidation statute? I don't have time to look all that stuff up, but I know you guys will. Just for clarification purposes, my name is Melanie, not Melody, like the song. My sister sent me something the other day. She's like, are you listening to John Mayer on Sirius XM right now? And I said, no, I'm not. And she said, oh, there's a song called Melanie, and it's by a band called Player. And she's like, let me send it to you. It just came out 2 years ago. So then when I had the opportunity Look at it, what she sent me. It's a song from the 70s, and it's by a band called Player. And you may remember Player because they had a famous song called Baby Come Back, Any Kind of Fool Could See. Remember? There was something in everything about you. Remember Baby Come Back? And they all, like, in the video, the YouTube video, they all have like long, like Sean Cassidy hair. And there was a song called Melanie. Who knew? I have a song out there. John Mayer loves it, and he was playing it on his channel. So there's that. So I got that going for me today. Jeannie Karen Reed for governor of Massachusetts says this motion is a smokescreen and purposely written in double Dutch to create confusion, more delays, and cover for the Commonwealth. How awful for Karen. Yes. Yes, because just when she thought her nightmare was over, it ain't over. It ain't over. Now she's got to worry about this. Thank you for your super chat. Cookie Doodle became a member. Welcome. Think you're going to like it here. Paul says 2 streams in one day. I love you with all of my heart. Yeah, we're going to come back at 2 and cover the Brian Walshe hearing. It's scary. So there's that. Going back to the affidavit at issue before I went off on my little side quest, as we often do. And if you have ADHD, you'll understand. Oh, look, something shiny. Oh, look, something shiny. And then there's the, maybe we'll look up the other statute later, but let's try and get through this because we got to come back at 2. We're coming back at 2, and I want to, this is a long affidavit. So now he calls it intimidation of a witness. I should have just went to the next page. Violation of Massachusetts General Law 268, Section 13B. And here's his fact pattern, Tully's, that is, to show that he thinks that Karen Reed has committed intimidation of a witness. On the morning of January 29, 2022, John O'Keefe was found unresponsive on the front lawn of 34 Fairview Road, Canton, Mass. He was transported to Good Samaritan Hospital where he was pronounced deceased. The officer of the medical examiner determined the cause of death to be blunt force to the head and hypothermia. Hypothermia was debunked in trial 2. We were here, we saw it. Evidence was presented to the Norfolk grand jury that indicated on the night of January 28, 2022, Reed and O'Keefe were at 2 Canton restaurants, C.F. McCarthy's and the Waterfall, where they met friends. After the Waterfall closed shortly after midnight, Reed and O'Keefe were invited to 34 Fairview Road, Canton. Witnesses stated Reed and O'Keefe did not enter 34 Fairview Road. The Norfolk County grand jury indicted Karen Reed on second-degree murder, motor vehicle manslaughter while OUI, and leaving the scene of a motor vehicle crash causing death. The indictment alleges Reed struck O'Keefe with her motor vehicle and left the scene. The case is currently pending in Norfolk Superior Court. Remember, this affidavit was drafted before trial 1. The lead investigator for the above investigation is, guess who? Trooper Michael Proctor of the MSP. As much as they tried to get away from him being the lead investigator, Tully says it outright in his search warrant application under oath, swearing truth. Trooper Proctor testified before the grand jury and continues to conduct investigative work on the case. Michael Proctor is married to Elizabeth Proctor. Elizabeth is not a witness to the investigation, but a family member, as mentioned in the statute. During the investigation into O'Keefe's death, witnesses were identified, interviewed, and testified before the grand jury. These civilian witnesses were present with O'Keefe and Reed in the hours leading up to O'Keefe's death and his discovery on January 29th of 2022. The witnesses include Matthew McCabe, interviewed by investigators. Matthew was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death, observed an SUV believed to be Reed's in front of 34 Fairview Road, and testified at the grand jury. Jennifer McCabe, Interviewed by investigators, Jennifer was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death, observed an SUV, believed to be Karen Reed's, in front of 34 Fairview Road, was with Reed when O'Keefe was found unresponsive, and testified to the grand jury. Brian Albert, interviewed by investigators. Brian was with O'Keefe and Reed at the Waterfall restaurant, homeowner of 34 Fairview Road, and testified at the grand jury. Julie Albert, wife of Chris Albert, interviewed by investigators. Julie was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death and testified at the grand jury. Chris Albert, husband of Julie, first interviewed by investigators on February 10th of 2022. Chris was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death and testified at the grand jury. Well, guess what else? In Chris Albert's original statement to police, you know, because we've been here for many, many, many seasons. Chris Albert says, I followed back to 34 Fairview. But now he swears he didn't. Colin Albert, well, they cut that part off. Interviewed by investigators. That's cut off, but we know he wasn't interviewed until like 18 months after. Juliana Nagel, interviewed by investigators. Juliana was present at 34 Fairview Road when people were arriving from the Waterfall restaurant and observed an SUV parked in front of 34 Fairview Road. You know what it doesn't say in this affidavit from January 2024? That she observed a black blob on the lawn, at least 6 feet in length. In an April 2023 motion filed by Reed's defense attorney, defendant's motion for order pursuant to Rule 17 directed to Brian Albert, Verizon, and AT&T, alleged police misconduct and a conspiracy among the civilian witnesses to frame Reed for the death of O'Keefe. The motion calls Brian Albert a suspect and Jennifer McCabe a conspirator who took calculated steps to purge her phone of this inculpatory evidence. Well, I mean, if the shoe fits, she did delete Google searches, and Karen Reed's been acquitted in the murder of John O'Keefe, so somebody else did it. And my money is on somebody else who was in the house. So you got your choice of, like, I don't know, 11 people. A local blogger, Aidan Carney, has adopted defense's claims. Carney runs a series of websites and social media accounts under the name Turtle Boy. And they say how many followers he has in each. Oh, and look, he only had 48,000 subscribers when they did this on YouTube, and now he's up to like well over 150. He refers to his followers as Turtle Riders. Beginning on April 18th, 2023, Carney began posting articles to his website and social media accounts where he adopted the defense allegations as true and makes personal attacks on the civilian witnesses, members of their family, and their friends. Carney authors and publishes a blog on the website tbdailynews.com. Well, thanks for shouting out his website so everyone can go look at it. The website has a series of articles entitled Canton Cover-Up. As of December 21, that was 2023, at least 259 articles have been posted under this category regarding Karen Reed. I don't know how many it's up to now, but you guys probably do. And then they go on, or Tully goes on to talk about Carney a whole bunch more, because this is probably a scratch and sniff from the exact affidavit that he used to get Carney's phones for witness intimidation, I would bet. And so I'm going to scroll through this slowly so you can read it more at your leisure. But paragraph 9 talks about Aiden's videos to YouTube, where he has made statements regarding witnesses. And this will go on for probably a couple of more pages. And then paragraph 10 says, since April 2023, Carney had traveled to Canton on several occasions. On one occasion, he went to D&E Pizza, which is owned by Chris Albert. Chris Albert and his wife, Juliana Albert, were with John O'Keefe and Karen Reed prior to the homicide. Chris has been interviewed by investigators. During the visit to D&E Pizza, Carney confronted Chris. Carney later stated on a video posted on YouTube for his followers to confront Chris Albert, order food from D&E Pizza with the intent of not paying for the food, and harass Chris Albert. Stated he has had a vast increase in the number of, and harass, period. Chris Albert has stated that he has had a vast increase in the number of telephone orders not picked up or paid for since Carney made those statements on the YouTube video. They're so obsessed with Turtle Boy and Karen. That is really disturbing, says Wendy Taylor. Letteros by Betteros says, that never happened, ever. Gentle reminder to the chat that just because Tully says it and swears to it in this affidavit does not make it true. In July of 2023, Carney posted a blog on his website about Chris Albert. Carney writes, let's keep this up. Again, all stuff that he says Carney is doing. Another video that Carney broadcasted, a live YouTube presentation on June 13th, 2023, where he called Juliana Albert and left a voicemail message. I mean, we got to read it. We got to read the voicemail that he left for Julie Albert. Here it is. Hold on, I need a drink. Paddle and Loon pointing out that Turtle Boy was receiving unsolicited pizza orders at his home during his stream. Every accusation is a confession with these people. And Melisa pointing out that Jennifer McCabe did ask Marcy, can you get him to stop blogging about me? Get your popcorn. Here's another. Here's the voicemail that he allegedly left for Julie Albert. Let's take down Chaka and put up, well, here's the original picture that we had of Michael Proctor, but after his glow down, we put this picture up. So we'll use that one for now. Hi, Julie. This is award-winning journalist Aidan Carney calling from Turtle Boy Daily News. Just calling to ask you a few questions, that's all. At the board selectman meeting a few weeks ago, you looked great and extremely happy in the front row and extremely comfortable that you wanted to be there. So I just want to ask you just a couple of questions. I'm reading a police report right now from February 10th, 2022, which Michael Proctor says he interviewed you and introduced himself for the first time, which confuses me a little bit because it seems that your family has known him for quite some time. I was wondering how your son Colin, who was at 34 Fairview Road the night that John O'Keefe was murdered, ended up in a wedding party with Trooper Proctor and Trooper Proctor's sister before he was actually a trooper. And I wanted to know, who did you guys meet? And did you guys just forget about each other over time that you had to be reintroduced again? But what I'd really like to know is if you were at the Canton High School class of if you were in the Canton High School class of 1994. How the hell did Jen McCabe win Best Looking? Were they using Dominion voting machines? How did that happen? And how does that hurt your self-esteem to know that you were in the same graduating class as Jennifer McCabe and she got Best Looking? How do you cope with that? Do you need therapy? That has to hurt your feelings, right? Because that would just devastate me if I lost to a horse face. So give me a call back when you get this and we'll talk soon. Bye. Chris Albert stated that he received a phone call from a phone number with a 413 area code on June 19th of 2023. Chris Albert did not answer the call. The following voicemail was left. Yes, Chicken Parm Charlie. This is award-winning journalist Aidan Carney calling you back. You messaged me on the night of April 17th when I first wrote a story about your son being involved in the death of John O'Keefe. You said it was unfortunate that I was going to write about that. I also have not heard back from you yet, so I'm still following up on that. I'd also like to know about a report that I'm reading right now in which Trooper Proctor claims that he was formally introduced to you. Remember, it said after formal introductions. Proctor claims that he was formally introduced to you on February 10th of 2022. I'm a little confused by that because we have pictures of your family with Trooper Proctor dating back as far as I believe 2011, if not further. So did you guys both have amnesia that day that you needed to be formally introduced? Do you often need to be introduced to the people that you have known for a long time? Do you live perpetually in Groundhog Day? I know this was right around Groundhog Day when this happened. So maybe it just kept replaying and you got to do it all over again the next day. I don't know. I'd like to learn more about this. So if you get back to me, that'd be great. And also I'd take 2 blackened chicken parms, extra mozzarella, and we'll see you soon. All right. I mean, is that a violation of the witness intimidation stuff? This is what you call old school journalism. This is what you call reporters knocking on doors and asking the questions. Why is it that a guy like, and look, I like Brian Enton, so no shade to Brian Enton, but when he's camping out on Roberta Laundrie's lawn for I don't even know how long, and I don't know if it was just Brian Enton, but there was other people shouting questions at Roberta Laundrie as she left her house about where's Brian, and you know what Brian did. This is journalism, okay? Why is it that other reporters in Massachusetts, for example, the one who went to Proctor's house, I think, and was yelled to get the F off my lawn by Proctor and I think his wife, wasn't that? Why were they not charged with witness intimidation? Right? So many reporters did that. So many reporters do that on a daily basis. And that's called journalism. I don't see him threatening either one of those people in those messages, but here we are. On July 23rd of July 26, 2023, Sergeant Yuri Buchanan of MSP interviewed Colin Albert regarding harassment he's received from Carney and his followers. Okay. Wasn't this also the first time MSP ever interviewed Colin Albert? July 26th of 2023? Right? Colin Albert is the son of Chris and Juliana Albert and was 17 years of age on the day O'Keefe was killed. On April 17th, 2023, Carney posted on Twitter a statement alleging Colin Albert is responsible for the murder of John O'Keefe, specifically stating Colin and O'Keefe were in a fistfight at 34 Fairview Road. Since that post, Carney authored several additional posts about Colin, his alleged propensity for violence, and personal information, including where Colin will be attending college. Since that time, Colin has been the target of harassment and intimidation on social media. Employees of his college, Bridgewater State University, have received emails from people who copied Carney's false allegations. Well, it might be time to point out that Elizabeth Proctor allegedly called a bunch of people's employers and tried to get them fired, maybe even did get them fired for saying mean things on Facebook or something like that. And then, apparently, allegedly, he called Colin Albert on his show and said this on July 8th of 2023. Yo, Colin, it's Turtle Boy from them Advantage Boys. Bang, 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 bang. Yo, we'll F any of you dogs up. Yo, you challenged my boys, them Advantage Boys, to a fight, dog, and we about that life, son. We about that life, and we from Sharon, son. Yo, y'all Canton Bianchas ain't hot. Yo, us Sharon bitches are Advantage Boys. Nobody be effing with us. And dog. Yo, call me back. No, but seriously, it's Aiden Carney from Turtle Boy. I just want to know, were you the one who killed John O'Keefe, or was that your Uncle Brian? Who hit him first? Who hit with the back of the head? Who hit with the back of the head with the thing? Are you worried that you're going to jail for the rest of your life and that you won't be able to play football at Bridgewater State next year? I'd love to have a conversation with you. Your dad kicked me out of your pizza shack and I didn't get to eat his mediocre chicken parm. So I just wanted to know if you could talk to me about that. Maybe you and I could go for a ride. We could find them Advantage boys. Bang, bang. I don't know. So give me a call when you get this. Bye. And here's the thing. Again, journalism mixed with a little comedy, satire, and Karen Reed's been acquitted. So she didn't do it. Somebody else did. And Turtle Boy may have been right all along. Colin told Buchanan that he's really scared, sad, and paranoid, that he fears physical harm from strangers. And then on September 24th of 2023, in another YouTube presentation, Aidan Carney is talking about an interaction that he had with Jillian Daniels, Colin's aunt. While describing their interaction, Carney stated, "I'm trying to put her like godson / nephew in jail and, kind of like destroy their life." Carney has targeted Jennifer. Okay, so again, all of this is stuff about allegations against Aidan Carney harassing witnesses, right? And it goes on and on. And then Carney goes to the McCabe's, went to Billerica for a lacrosse game, and Carney went there and he said to them something such as like that. While the McCabe's were seated in the stands, Carney approached Jennifer McCabe and asked her repeated questions about the alleged conspiracy. And then he said, then he bragged about it, says Tully. "I went to her kid's lacrosse game and made a scene there and got kicked out because I kept calling her a cop killer." I mean, the grand jury already kicked out their first attempt. You're correct. Then he went to the McCabe's house, apparently, on June 26, 2023. The door was open. He recorded a video there. He rang the doorbell. Recorded it for a minute, and apparently nobody came out of the house. And then Buchanan interviews Jennifer McCabe. She's concerned for her safety and well-being of her children. Her children are upset and embarrassed. But again, this is all stuff that Carney allegedly does. September 20th, during his YouTube presentation, he said Carney repeatedly stated that Jen McCabe killed John O'Keefe. I really don't think that he said that. At the 154 mark in the video, Carney stated, I'm saying this as a matter of fact that Jen McCabe participated in killing and planning to kill and murder and the cover-up and murder of John O'Keefe. I'm saying that. That is not my opinion. First Amendment. First Amendment. Here's some more stuff that he said on a YouTube presentation and more things. And these are all reasons why they're charging Aidan with witness intimidation. And then he left Proctor a voicemail, allegedly, on June 13th of 2023. He called Proctor and left this voicemail. "Hi, Trooper Proctor. This is award-winning journalist Aidan Carney calling. I'm calling to talk to you. I do have some questions about you. I have a lot of questions, actually. For starters, why didn't you tell me, one, before doing the investigation, that you were good friends with the Albert family? Why did you, in your report, say that you were introduced to Chris Albert on February 10th when you have known him for more than a decade prior to that? Why did you lie about what time you towed Karen Reed's car? Guess what? All this stuff is true. Why did you intentionally misspell the names of several key witnesses in your report? And, I'm just wondering about all those things, and maybe you and I can meet up for coffee. All this stuff is true. Boy, do I have a lot of questions for you. When you were inside Fairview Road that night, or that morning rather, why did you stay there for 4.5 hours? And what did you guys talk about and do? And why were you descending stairs with John O'Keefe's phone in your pocket? So give me a call back, man. We feel like you and I have a lot of catching up to do. I talk about you a lot. I feel like I know you pretty well at this point. I know what year you graduated from the academy. I know you're out in West Brookfield for a while. I know some people that you know. So give me a call back when you get this. Let me just take this down for a second in case any phone numbers are on here. Now that I have your number and everybody's watching also has your phone number, which again is, and then he says the phone number. So I'd like to know. She called you again. You called her at 12:49. We're going to get to that. So now I have your number. I'm going to plug you in. We'll talk soon. Bye. Bye. As a result, Trooper Proctor began to receive random and harassing text messages and phone calls, and he was very, very sad. And he had to change his number. Michael Proctor's married to Elizabeth Proctor, and again, alleging that Aiden said things about Elizabeth Proctor. He allegedly wrote on May 9th of 2023, a post about Elizabeth. I can think of two people who deserve to lose their jobs over this, though. Michael Proctor and Elizabeth Proctor. Well, isn't that ironic, don't you think? Because guess who did lose their job over this? Michael Proctor. It's all true. These two lowlifes think they're untouchable. They're nothing but bullies who terrorized people for years, but now they've met their match. And then he says he gives out Elizabeth's work phone number. Another YouTube presentation. And here's the following message that he left for Elizabeth Proctor. Elizabeth was in human resources, says, I think. She was a human resources manager because she's really good with people. And she probably knew what to say to call to try and get someone fired if she was in human resources, right? Here's the alleged voicemail that Aiden left for Elizabeth Proctor. Hi, Elizabeth. This is Aiden Carney calling you back from Turtle Boy. We briefly spoke yesterday on the phone. I introduced myself to you and then you hung up on me, or maybe it was a bad connection. But I just wanted to see how your day at work went today, if it went well. I noticed that your employee took down their social media pages within minutes of the blog I published about your recent behavior. And I just wanted to see is it awkward? Were you afraid to go in? Just tell me about your day and why, because that's the part I don't understand, is that you seem to be okay with calling other people's workplaces and interfering with their ability to make a living for themselves. But when it happens to you, maybe it's not as fun. Maybe it's not as fun. Do you like that? That's what I want to know. Do you like that? Because you've been doing that to a lot of people. And do you think it's fair that it happened to you, dear? Do you regret it? Do you regret it? And what's your scumbag husband up to right now? Are you going to visit him in prison? Do you think they'll have conjugal visits? Give me a call back when you get this and we can chat some more. Bye, girl. Moving on. He showed a photo on September 20th, 2023 on a YouTube video. A photo depicting Brian and Nicole Albert, the face of Irish poverty, at a Bridgewater State University football game. He described the photograph as the most satisfying photos I've ever seen. The photograph depicts Brian and Julie Albert hiding their face while a group in front of them in the stands takes a photograph. Carney later stated, "This is how they live now, like rats. This ends when they go to prison." I mean, if this is all the evidence that they're going to try and use against Aiden Carney in some trial that who knows when it would happen, if this is all the evidence that they're going to use to say that he harassed and intimidated these witnesses, the grand jury is going to be sitting there, or the jury in this trial is going to be sitting there like, but wait a second. We know, because we live in Norfolk County, Karen Reed was acquitted. John O'Keefe wasn't hit by a car. So he was just trying to get the real story to come out. And what did he really do here? That's actionable. Is he guilty of anything other than trying to get a story? No, not guilty. Right? Yeah. And are they mentioning Karen's name yet? No. And they talk about him putting up a billboard, or somebody put up a Free Karen Reed billboard outside Gillette Stadium in Foxborough. And then he did the rolling rally. And the houses that they went to on the rolling rally. Nobody was arrested, by the way, at the rolling rally. And they knew the rolling rally was happening. I know it's supposed to be about Karen, so they keep going on and on about the rolling rally. And then, tenuously, they're going to try and connect Karen to some of this stuff. So let's see if we can find it. At what page in this 31-page affidavit does it come? But here's a good point. Here's a good piece. When Carney arrived at 31 Fairview Road, I guess this is during the rolling rally, he identified the home as the residence of Deputy Chief Thomas Kelleher. He stated, Tom Kelleher knows what happened. He's not stupid. He's seen what happened. He knows the exact time John O'Keefe's body was taken. Carney then described how allegedly O'Keefe's dead body was brought by a vehicle and thrown onto the front lawn of 34 Fairview Road. Carney pointed the camera at the Kelleher home and said, we know that guy who lives in that house is part of the cover-up too. He's a police officer. People trust him in this community. If you're a neighbor here, please know that this guy is covering up for a cop killer. Your neighbor, Tom Kelleher, is complicit in the death and murder of John O'Keefe. He's complicit in framing of an innocent woman who did nothing wrong by the name of Karen Reed. And we're here to let you know that Tom Kelleher is your problem. We're not going to let him, Kelleher, get away with it. He was in front of the residence for approximately 10 minutes. Aiden was never charged with witness intimidation on Tom Kelleher. Never. Ask yourself why. Why? Because Kelleher probably wanted no part in that. Because maybe there was something nefarious that happened with the Ring camera footage from Kelleher's house. Because if you recall, I don't even know if it was Canton PD or MSP, went to Kelleher and said, hey, you got anything on your Ring cam? And he was like, yeah, no, nothing interesting. I already looked at it. And they're like, okay, bro. Trust you, bro. Bye-bye. No worries. Got nothing. And then again, going on, the rolling rally. Finally, he gets to a section called Information Subsequent to the Arrest of Aiden Carney. Tully apparently traveled to California in October 17th of 2023, to Gardena, California, to interview Natalie the German, Natalie Wywicki Berschneider. Natalie attended Bentley University with Karen Reed from 98 to 2002. She was not close friends with Karen, but she had friends in common. Following graduation, Natalie returned to California and lost touch with Karen. But after Karen's arrest, Natalie inserted herself back into Karen's life by contacting Karen to offer support and began a friendship. Natalie said that Karen openly shared her defense theories about the case, which Natalie stated she believed at the time. In April 2023, Natalie noticed a woman by the name of Jennifer Altman on social media. Altman, did you know that you're in this? Look at you, Altman. You're famous. You're in Tully's search warrant application. On social media, who was defending Karen in comments of news reports regarding Karen's criminal case, Natalie stated she contacted Jen Altman on Facebook in order to thank her for supporting Karen. Jen Altman responded that she has a friend, Aiden Carney, who runs a blog and would like to report on Karen's criminal case. Well, look at Jen Altman trying to get Carney the inside dope, which, by the way, there's nothing wrong with doing that. During this text message conversation on April 13th, 2023, Natalie sent the following message to Jennifer. The feds are involved, and described how people involved were going down. Well, we can only hope. And also, that wasn't a lie either. Well, people going down. Nobody's gone down yet. Well, except for Matthew Farwell for the murder of Sandra Birchmore. Natalie spoke to Karen about Carney. Here's the thing. October 17th of 2023, which is when they flew Tully all the way to California to interview Natalie the German, was probably after Natalie and Karen broke up, because Natalie felt like she was, ghosted, and she felt slighted because Karen, I guess, cut ties with her. On April 17th, 2023, Natalie was put into contact with Carney through Jennifer. So Natalie and Aiden start corresponding. Shortly after Karen agreed to work with Carney, Karen instructed Natalie to download the messaging app Signal on her phone. Oh, here it comes, Signal, which she did. Nothing wrong or illegal at all with the defendant working with a reporter, by the way. Nothing wrong with that at all. Natalie's understanding of Signal was that it is a more confidential way to communicate, as the messages can be auto-deleted after reading. Natalie described the arrangement as follows. Karen would send Natalie a message on Signal intended for Carney. Natalie would copy and paste the message, photo, video document into a text message to Carney. On several occasions, Natalie would take a screenshot of the Signal messages from Karen and send Carney the screenshot. Natalie stated she would send information to 2 phone numbers used by Carney. So Natalie is now sending stuff to Carney, including information regarding witnesses, the home address of Trooper Proctor, pictures of witnesses, autopsy photographs, motions filed by her attorneys, police reports, photographs taken by the MSP crime scene services, and feedback about Carney's blog posts, social media videos. This arrangement began on April 17th. The check of the text message on Natalie's phone confirmed Natalie's statements. Carney would frequently check with Karen through Natalie if he could use a piece of material in his blogs. But again, this was drafted January of 2024. Natalie said at one time, "Don't talk about those on the show tonight." On April 29th, Carney asked if he can talk about or use different material on his YouTube show. Natalie said, "Make it clear he didn't just get it from us. But don't show the exhibits, just read them. And please tell him not to share the title. It has Yannetti's initials in it." Referencing David Yannetti. In mid-May, Carney sent Natalie a picture of himself wearing a t-shirt depicting a Google search bar with the phrase, "Haas long to die in cold." Hilarious. Natalie responded that she will ask Karen if he can wear it to court. Natalie later tells Carney, "It's okay to wear the t-shirts. Haas long to die in cold. I got the okay." Carney responded, "Really? You asked Alan?" Over the course of the text message conversations, Natalie forwards personal informations and pictures of many of the named witnesses above, including Jennifer McCabe, Chris Albert, and Colin Albert. In one part of the conversation, Carney wrote, "Anything else I should talk about? I haven't hit in blogs yet. Feel like I'm out of new material." Well, guess what? All of their addresses are public record, and they were also included in the witness statements. Natalie stated a second person was acting as an intermediary between Karen and Carney, John Silvera. That statement is corroborated in several text messages between Natalie and Karen. And this goes on and on and on. Trying so hard to prove that Karen was conspiring to commit witness intimidation with Aiden. Carney sent a message to Natalie. "It's really important for me to know how we know Colin was in the house." Well, What does that say to you? That says to me that Aiden's looking for receipts, and he needs receipts that Colin was in the house because he's not going to report on it if it's not true. John is one of Karen's best friends. This is KBD. Right. And this all came out in the documentary, says Mo. That's right. In the documentary about Karen Reed, before the second trial, Karen does say she was sending stuff to Turtle Boy via a second person. And then she just started to send things to him herself. That's correct. Thank you for your comment time, Trap, but we don't do politics here. He says, well, I'm starting to lose confidence. Colin was in that house and I'm freaking out. Natalie sent this message. Brian and Nicole and Chris and Julie all testified he was there. Well, that's interesting, but I can't send grand jury testimony because it's sealed. Wow. Carney wrote on May 7th, not going to lie, this is getting old. I don't like the riddle, put the clues together stuff. This isn't a board game. By now, she knows that I can be trusted, meaning Karen. What you told me that the 227 Google search makes no sense. He's looking for the truth. There was never a gag order, no. Well, not before the first trial. They tried to get one, Amy Adams, I may or may not be famous. They tried to get one around August 2023, and they couldn't get it. What had happened was the judge denied it, and that is when Michael Marcy made his hostage video. You know, you know. I think that there was a gag order before the second trial. Not at this time, though. Glamasu said Karen had every right to get her story out. The DA solicited people to talk for them and put their lies out. 100%. 100%. I have questions. Says you're allowed to talk about grand jury testimony. You can't send actual copies unless you're a grand juror. Yes, we do know that she's added Cosgrove to her lawsuit, which is why he's going to have to recuse himself. He's now got a conflict. He can't prosecute Aiden for anything because now he's going to be allegedly a co-defendant. Okay, moving on. Then they talk about some court dates, and then Natalie recalled Carney being invited to have lunch with Karen and her defense attorneys, including Alan Jackson and David. Again, nothing wrong with talking to reporters. There's nothing wrong with that. Blah, 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 blah. A check of the text messages from Natalie's phone reveals several instances where it appears Carney communicated directly with attorneys Alan Jackson and David Yannetti. The first being on April 22nd, 2023. Natalie sends Carney a message. Did you talk to AJ today? And Carney responded, just saw this text, gonna call him in a bit. So what? This is why they tried to get, I think, his communications with Yannetti. Because Tully says this in his affidavit for the search warrant. And Brennan must have been like, oh, we got to get those messages. Let's try and get those messages. On May 2nd, Natalie sent Carney the message, Colin has a lawyer. Ask Yannetti about it. On May 5th, Natalie sent Carney the message, tell Turtle Boy from me, be strong, Aiden. Get down for a day, but wake up and keep fighting tomorrow. Please call Alan and spitball your issues with him if you want to. And nothing gives you a shot in the arm like talking with AJ. Natalie later asks, did you call him? And Carney replies, just did. Okay, so what? They're really grasping at straws here. And you know how much I hate paper straws. They're grasping at wet paper straws because paper straws disintegrate within 30 seconds of you trying to drink something out of them. On May 7th, Carney stated he disagrees with Alan Jackson's theory of when O'Keefe was allegedly moved to the front lawn. Carney wrote, "Keep in mind, Karen, AJ, and myself don't officially talk. It would be normal for me to have opinions that different from the defense, although we all agree that Karen had nothing to do with it. I made it clear that my theory of how he died is simply that, a theory. If there's more information I haven't been given that can prove me wrong, I'm all ears." In public settings, Carney and the attorneys for Karen Reed have denied communicating or mischaracterized the nature of their communications. On September 27, 2023, Boston Magazine published an article about the homicide of John O'Keefe and Karen Reed's defense. For the article, the author interviewed Karen, her attorneys, and Aidan Carney. Is this the one that Gretchen Voss wrote? Because didn't Gretchen Voss, the reporter, like allegedly go out to dinner with Kate Peter and may or may not have done psychedelics with her? Wasn't that the tea? On that? Jews, guys. Second. You can't make it up. You just can't make it up. Yep. Glamasu says they talked about that, and it's amazing how that was hushed up real fast. For the article, and in the article, the article states both Carney and Reed's defense team say they have never been in contact with one another. Okay, so we're accepting the Boston Magazine article as truth, which is like hearsay. Okay, whatever. I observed text messages between Natalie and Carney containing discussions about an investigation being conducted by the FBI and the U.S. Attorney's Office. On one such occasion, in an April 23 message sent by Natalie to Carney, not public, the feds have been involved longer than anyone is likely guessing. On April 28th, Natalie sends Carney the following message, but I don't understand why he doesn't mention more than the feds are involved. The first assistant U.S. attorney, they don't shoot and miss. They have a case and way more evidence than we do. I know this for a fact. Jen McCabe testifies this coming week. I'm not sure about the others. Again, they're talking about the FBI and handing out subpoenas. And you know who else knew about it? Morrissey, because all the witnesses that were scheduled to testify in front of the federal grand jury called Morrissey to tell him that they were called to testify. And he started ramping up with his letters to the Attorney General or the AUSA, Josh Levy. Ramping up, trying to figure out what they knew. So they are going to try and twist themselves into a pretzel. Cosgrove is now going to be a contortionist to try and get a taint team for these phones that they've had in their possession since January 2024, but they've never extracted the information. I find that really hard to believe. And then they go on, and I'll scroll through this slowly so that you can read it to yourself later if you want to. Go on to talk about a footnote in a motion made by the defense. Multiple witnesses in home where John O'Keefe was killed, subpoenaed by federal grand jury. FBI visits homes. Basement floor reportedly replaced. All of that is true. Remember? Jennifer McCabe lied to the FBI when she came to their house. She said it was like not a big deal. It was like the ice cream truck coming to your house when you're a kid. And she said she lied about who she was. She said she was Nicole. She went in her house. The FBI called her and she said, "Oh, yeah, I'll talk to you, but I need 10 minutes." And then in that 10 minutes, she called something like 5 people, but lied to the FBI about who when they said, "Did you call anybody in these 10 minutes?" And she left out a couple of people. She admitted to calling her husband and one other person, maybe Kerry Roberts, but she failed to mention she called the DA's office, Brian Albert, and Peggy O'Keefe. They go on to talk about more YouTube presentations of Aiden. And remember, this search warrant is filed in January of 2024. Aiden's in jail for what was supposed to be 90 days based on the conspiracy to put him there, in my opinion, that was between Mello, Tully, Kate Peter, and Lindsay Gattani. Because now all of the text messages between them are starting, they've been turned over. Some of them have surfaced. Serving a fake grand jury subpoena. Tully served a fake grand jury subpoena on Lindsay Gattani on December 22nd, 2023, to make her a, quote, witness under the statute. Used her as a honeypot trap, or what do you call that, a honey trap? Honeypot trap? I don't know. To get Aiden to her apartment. And while Aiden is in her apartment, she's on the phone with Mello saying, "Don't call me because he's here and he's outside the bathroom door." Mello is the one who originally took this to the grand jury in March of 2024. And he has since been disqualified from prosecuting Aiden Carney. So let's just wait for this giant motion to drop this week that Bettero is going to file and see if we learn anything more about Mello Yellow. Because that's what's going on in the background during this time period. And remember, Aiden Carney's defense now has all the comms. They're still under a protective order. But Aiden has said on his shows, wait till you see the messages on the morning or January 22nd, 22, or the day after, or February, maybe the day of Karen's arraignment, I can't remember when, between Jennifer McCabe and Kerry Roberts. Wait until it's going to blow your mind. He said, you thought that the Proctor messages about Karen Reed were bad? Wait until you see what we have. Just wait. I don't know. Moving on. Karen Reed went on Nightline and Dateline, Boston Magazine. She has not acknowledged speaking with Carney. Who cares? Furthermore, she took steps to provide Carney non-public information while appearing to be distant, including using an intermediary, controlling what he can possibly publish, and using a messaging application outside of traditional text messaging. So what? So what? That is evidence of nothing. That is evidence of nothing. That is not a crime. Following a falling out between Natalie and Karen in June of 2023. Oh, yes. So I was right. Tully did interview Natalie after Natalie was ghosted by Karen and cut off, and Natalie's scorned. The text messages dramatically dropped. Natalie was no longer sending Carney information, blah, 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 blah. A special prosecutor convened a grand jury to investigate the intimidation of witnesses involved in Commonwealth versus Reed. Okay. That was, the grand jury summons was issued to Verizon requesting call detail records. Hold on. Of Aiden's phones. Then what had happened was, that's not our number anymore. Oh, 189 phone calls between Karen and Aiden. Over 40 hours of phone calls. Oh, that's how all this leaked out by the paid trolls for the Commonwealth, right? Oh, Aiden also may have called David Dinetti and Alan Jackson. So what? Big whoop, 29 times. On October 10th, 2023, Aiden Carney was arrested pursuant to several arrest warrants issued out of Stoughton District Court. He was arraigned in Stoughton District Court on the same date, which was widely reported by local media. On October 12th, Natalie received a call on her cell phone number, which is the main number of Worksman, Jackson, and Quinn, the California law firm of Alan Jackson. Natalie stated she did not answer the call, nor did she return the call. She stated she's never spoken to Alan Jackson, David Dinetti, or any other attorney representing Karen in the Commonwealth versus Reed prior to October 12th or since. On December 20th of 2023, the Norfolk County grand jury returned indictments charging Aiden Carney with 9 counts of intimidation of a witness, 5 counts of illegal picketing of a witness, and 3 counts of a conspiracy to intimidate a witness. Well, look at the timing of this, will ya? December 20th of 2023, that's when the grand jury returned the indictments. December 22nd, Tully issues a fake grand jury subpoena to Natalie. There you go. There's the receipts. The grand jury on Aiden was finished. They returned their indictment on December 20th of 2023. The grand jury was over. There was no other grand jury. Oh, Tully, you got some splaining to do, because we looked at that grand jury subpoena the other night. And it's dated December 22nd of 2023. And it was for her to appear somewhere at the end of December, like December 27th of 2023 or 29th. I don't remember, but I do remember it was between Christmas and New Year's. And I was like, there's no grand jury sitting between Christmas and New Year's. His grand jury was already over on the witness intimidation, and the crime, the alleged crime against Lindsay Gattani had not yet happened. So what do you think that she was going to be a witness in? That was fake. It was a setup. It was a conspiracy to have him arrested. And there you go. How much more information, how much more evidence do you need that Brian Tully, Ken Mello, Kate Peter, and Lindsay Gattani, who was likely used as a honeypot trap or whatever they call that, to put Aiden in jail? To get him to violate the conditions of his probation for the October 10th arrest, where they arrested him at his kid's bus stop. Tully did. This is disgusting. This is horrific. This is a violation of every constitutional right that you have. This is Massachusetts. And this is the story. This is the story. This story, I mean, you know, I hope Karen Reed has a great movie deal or other deal with whatever company she has her deal with. And Elizabeth Banks is doing another thing about Karen Reed. The story is Aidan Carney. That's the more interesting story, because you could pick Karen Reed out and pluck in anybody else. Anybody else. But what they did to a journalist reporting on a court case is outrageous. It's horrific. It is a violation of everything the First Amendment stands for. And it is a violation of everything that journalists do. This is the story, my opinion. Karen Reed could be anyone. We've said that a million. Karen Reed could be you, me, your sister, my sister, your daughter, your wife. Karen Reed could be any one of us. This is the story. Right? My opinion. I'm just a loud New York attorney with a microphone. But that's the story. That could be more interesting for a production company. What they're doing to him. He's facing over 100 years in prison for hurting the feelings of Elizabeth Proctor and Jennifer McCabe and Matt McCabe, when it turns out in the end, when all this shakes out, he might have been absolutely on the right track. And I don't understand the same thing. I agree with you. I've said this 100 times. And I'm going to say it again until my voice is even gone more than it is. That comment flew by so fast that I got to highlight it more. Need some Z's. Far more interesting. And I don't understand why every journalist in Massachusetts aren't outraged and covering Aidan's case 24/7. In case you don't know, Massachusetts is only one of a handful of states that does not recognize any sort of journalistic shield or privilege. There is no protection for reporters or journalists in the state of Massachusetts, none. And the fact that no journalists in Massachusetts want to touch Aidan's case with a 20-foot pole is shocking to me. It's shocking. I can't wait for Beto O'Rourke's motion to come out. I am like chomping at the bit. I'm on the edge of my seat. I am waiting for this thing to happen. Because as soon as it happens, we're going with it. We're just reading it. We're going over it. This is what you need to know. December 20th, that's when the Norfolk grand jury returned indictments against Aidan Carter. The grand jury was done. They were over. There was no grand jury in session. That subpoena served on Lindsay Gattani was fake. It was fraudulent. And it could be criminal. Who drafted it? It's a problem. It's a problem for them. And that is why they will not stop. And they will not leave Karen Reed alone. And they will not drop charges against Aidan Carney. And there you go. In December 2023, I communicated and interviewed a witness relative to the ongoing conspiracy to intimidate witnesses of the Commonwealth v. Reed case. Really? That's Lindsay Gattani he's talking about. He doesn't say the date, though. You notice how he doesn't say what date? Just December 2023. I interviewed her at her residence with another investigator. Given widespread media attention and ongoing intimidation of witnesses involved in the case, this witness will be referred to as by the pseudonym Jane. Right, because she had a fake Twitter account where she called herself Jane, right? The purpose of using a pseudonym in this affidavit is to prevent the public disclosure of her name at this point of the investigation. Lindsay Gattani. Her name is Lindsay Gattani. During the in-person meeting, Jane relayed the following information. Jane stated she met Aidan Carney in September 2023 after exchanging messages on Facebook Messenger. Jane stated she would communicate with two of Carney's Facebook profiles, Clarence Wood Emerson and Aidan Carney. Jane stated she then began communicating with him using this phone number. Carney and Jane met in person following a Commonwealth v. Reed court date and went to her apartment. After that meeting, Jane and Carney began having a romantic relationship, with Carney staying over her apartment Friday night. Well, I don't know how romantic it was. They never shared a meal of food, from what I understand. And then he's going to talk about all these things that Lindsay told him. Carney said he was close with Karen Reed's family. Then he told Jane he speaks with Karen Reed every day. Jane's showing him screenshots and a Signal audio call log. But again, he doesn't say what this date is, what the date was when Tully interviewed her. But we know that Lindsay had Tully's cell phone in her phone. And they were on that 4-way group text message with Mello, Tully, Lindsay, and Kate Peter, the not so confidential informant. And then he's going to talk about other things that Lindsay Gattani told him. And, because she's a really credible witness. But all this is an application for a search warrant. So this isn't even a search warrant. It's to seize the phones. Oh, and this is where this rumor came from. Jane stated different sources of financial benefit for Carney and his partners. Who are his partners? Jane stated that Carney's doing well with donations. Carney had alluded to the fact that he did not pay for a Lexus SUV he recently acquired. Oh my God. Do you remember when the Commonwealth subpoenaed and got Nathan Reed's banking records and Bill Reed's banking records to try and prove that they bought Aidan Carney a Lexus? Further records revealed the vehicle was paid in full using a personal check. Okay. Lindsay goes on to tell Tully a whole bunch of other stuff. That Karen Reed's attorneys were working with the U.S. Attorney's Office, Josh Levy. Here it is. Lindsay Gattani was served with a summons to appear before the grand jury on December 22nd of 2023. What grand jury? There wasn't one. Carney learned that Jane was served a summons and they agreed to meet at her apartment on the night of December 23rd. During the meeting, Carney told Lindsay Gattani to tell the grand jury she did not remember anything, delete evidence from her phone, and told her he would hire an attorney if she cooperated with him. Hire her an attorney. Carney later assaulted Jane, which he claims is not true. But they needed to get him on something to charge him and put him in jail, in my opinion. Which led to Medfield police charging Carney with assault and battery on family household member and witness intimidation. Well, she had to be made a witness, right? That's why they had to make up that fake grand jury subpoena. Carney was arraigned in Dedham District Court on those charges on December 26th. The assault and battery charges were dropped before Aidan got out of jail. Thank you, Glamasseuse, for telling me that. But because this alleged assault was a violation of his conditions of being out on bail, do not pass go, do not collect 200, he was put in jail on his birthday, I think. And I think he turned himself in. I think there was a bolo out for him. Turned himself in with Bradle, and then he went to jail. Norfolk County Pokey with Harry Turk and Brian Walshe. Based upon the following foregoing facts, there is probable cause to believe that Karen Reed committed a violation of Massachusetts general laws, section chapter 268, witness intimidation against Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Nagel, Michael Proctor, and Elizabeth Proctor, which reads, and then they quote the statute, which we've read a billion times, but I'll scroll through it slowly for you so you too can read it, because it also extends to family members of a witness. And it also extends to emotional harm. Based upon the foregoing facts, there's probable cause to believe that Karen Read committed a violation of Massachusetts General Law 274, Section 7, conspiracy to commit intimidation of a witness by entering into an agreement with Aidan Carney by providing information, photography, and material relative to her criminal defense and editorial oversight of blog posts and videos intended to harass, intimidate, and cause emotional harm. As if she wrote those blog posts. The information provided by Natalie the German and Lindsay Gattani outlines the close communication between Carney and Read. Communication has continued after Carney was arrested and arraigned on charges of intimidation of a witness. Read feeding Carney information was not only providing her defense theory, as she did with the national news outlets. Read and her attorneys and Carney have publicly mischaracterized their relationship. So what? They're not under oath. It don't matter. And a journalist doesn't have to reveal his sources in most other states in the country of the United States of America. Everyone uses Jane, right? Everyone uses Jane, says Alicia Smith. Clear motivation because of Carney's statements of jury influence. As the witness intimidation statute allows, Karen Read has indirectly intimidated and harassed the witnesses named in this affidavit. Evidence of such crimes will be found on the mobile electronics used by Read to communicate, harass, intimidate, and receive information. On December 23rd, 2023, I applied for and was granted a search warrant at a Norfolk Superior Court to seize any cell phones presumably used by Karen Read. Efforts to locate Read, well, it says efforts to location Read, within the 7 days of issuance of the search warrant were unsuccessful. On January 9th, 2024, I applied for and was granted a search warrant out of Norfolk Superior Court to obtain the real-time location information of the cell phone associated with the phone number and a separate search warrant to seize the device. I served a search warrant on Verizon and I figured out that Karen Read was in the seaport, and so I couldn't get it. And then she was in Florida on January 11th. She went and boarded an airplane at Logan Airport, and she went to Florida, which, by the way, also not a violation of her bail conditions at all. So she went to Florida, Sarasota. So then we had to get another search warrant because we couldn't do it in the proper time frame. And so now I'm asking you again, let us go get her phones. But we promise, Scouts Honor, that we won't search them until we get the proper taint team in place and, do all that stuff. And so here's Cosgrove, after Karen Read's acquittal, trying so hard to now get a grand jury to believe the BS that they want to spoon feed them. And also trying to get a judge to order a taint team, claiming that they never searched any of Karen's devices. I don't believe it, because without searching her devices, how would they have provided any evidence to the grand jury in 2024 that declined to return a true bill? Based on all the above, there's probable cause to believe the data held within the cell phones used by Karen Read will contain evidence of witness intimidation and conspiracy. That cell phone data has been used as a means of committing a crime and as evidence of criminal activity. And here is all the evidence for probable cause that he claims exists. Against the witnesses, including but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, and Elizabeth Proctor. and data evidencing the ongoing conspiracy with Aidan Carney to intimidate witnesses. And remember, at this point, Aidan Carney was already in jail. He says, Karen Reed has been charged with criminal offenses since February 2022 and has been represented by attorneys. It is reasonable to assume her electronic devices capable of communication would contain communications with attorneys that could be privileged. I respectfully request to only seize the devices, Tully said. Following the seizure of such devices, no search would commence until such time a taint team or special master protocol is agreed upon by prosecuting attorneys for the Commonwealth and defense counsel. Well, I don't think they ever agreed on anything with defense counsel because they were never told that the grand jury was hearing this conspiracy case. Once the protocol is agreed upon, I will apply for a subsequent search warrant to particularize the search. Any reference to searching of devices in this affidavit is mentioned merely to illustrate the purpose to seize such devices. Given the request of seizure only, I respectfully request the authority to download and preserve data of any device seized. The download of the data contained on a seized device would ensure the integrity of the data. I know through training and experience, users can erase data from a phone remotely. I respectfully request the authority to enter the phone for the sole purpose to place the cell phone in airplane mode, preventing the device from communicating and receiving an erase command. In the event the device is seized with a passcode, the download of the device would prevent the remote deletion of data. This affiant has access to software that can attempt to bypass passcodes of cell phones. Yeah, it's called Gray Key. The process of bypassing a cell phone code can take minutes, days, weeks, or months. In the event no passcode is obtained and the phone is locked, I respectfully request the authority to attach seized devices to such software in order to begin the passcode cracking process. In the event the passcode is bypassed, I request the authority to download such device. Just like they did in Brian Walshe. XOXO, Brian Tully, dated 1/22/24. Signed by Judge Krupp. He allowed it. And that's where we wait. Do you believe Cosgrove? Thank you, Jeannie. I think we did this before. We addressed that. Jamie Lynn says, I feel like I'm having deja vu. When did this come out? This motion was just filed August 28th, but this search warrant from Tully was from 2024. And the motion was filed August 28th, 2025. And you are having deja vu. Sue says, I just joined, but did you know that Ken Mello is representing someone in court today? It's a miracle. He's been cured. Oh, no, I didn't know that. That's insane. Oh, so he's able to come to court now? He's fully able to represent people? That's good to know. Thanks, Suze. Mel, have you received your silver YouTube button? I have. It's in a box. I've never even unboxed it because it came for the 100,000 subscriber celebration. It came during the Karen Reed trial. And so we've just never gotten around to planning a celebration to unbox it, but I will eventually one of these days when we're not inundated with breaking news. I also hate being the center of attention. So I want to do it and I want to invite people to come on and hang out, but I just haven't done it yet. But thank you. Martha Ivy says, thank you. You bring insight about the law. Thank you, Martha, for being interested enough to watch for a whole 19 months. Aunt Bibi says, if a grand jury would indict Karen, would that affect her probation? I'm very concerned for her. Thank you, Melanie. I'd have to look at the terms of her probation. And I don't know the answer to that. I don't know the answer to that. They could indict. I don't think they're going to indict. I don't think they're going to. I don't think it's going to be an issue. Thank you, Aunt Bibi. How can they? Look at who their witnesses are. Lindsay Gattani? She's got credibility issues, to say the least. Beto is going to probably drop a bomb this week that's going to blow the whole lid off of all of this stuff anyway. So I don't think there's anything to worry about. Yes, Aiden, aka Turtle Boy, is the story, says Ray Bay. Thanks for being here for 5 months. Gavel and Gloss, thanks for your super sticker. Ms. Bouquet says, great stream. Look after your voice. Thank you. Amy Adams, I may or may not be famous, became a member. Welcome. Joy, how can Kate Peter and all involved not be charged with fake grand jury summons, fake lawsuits, etc.? I think it'll happen. I think it'll happen. Kate Peter's been very quiet lately. I don't know where she is, but I don't know that she's been on the Twitter. I don't know where she is. Is she in hiding? I don't know what the statute of limitations is, but I think it's still, and if it's still valid. Teresa. Shaking my head. Number 16, though he was right out there in the video I saw when his father threatened Turtle Boy. Wow, just wow. This is wild. Thanks for all your time in here. It's greatly appreciated. Free camera, Turtle Boy. Thank you, Teresa. Thank you for your 10. Stormy, isn't there a military base near where she could throw it away and get a new phone? Don't you think? Well, they already have her phones. That's why this is why they don't want to release them, I guess. But they've already done the download. They don't need the physical phone. I don't know. I got a lot of questions. Tully and Jen McCabe are besties, says in Lemonade. Carla. Maria says, thank you, Melanie, for walking us through the crazy. Oh, you're so welcome. You're so very welcome. Eden Higgins, I did see this earlier. Update on Martha Nolan. Irish press reporting that her family are seeking a second opinion autopsy. Would that involve having her body exhumed? I thought they already got a second opinion autopsy, so I don't know if the Irish press story is new or old, but I can look into it. I assume that they would have done that before her burial, and she had a funeral in Ireland. We covered that. She was the young lady who was found on a boat in Montauk, deceased. Maybe drugs, they don't know. A lot of sus behavior in that, in my opinion. Here's an update. We're going to just pivot for a quick second because I do want to take some sort of a break before we come back here at 1:50 to cover the Brian Walshe, Miles King hearing. Andrea Burkhart had commented on this Cosgrove motion. And she said, her phones have already been extracted. Their sole evidentiary value is in the contents, which have already been obtained. There is no investigative reason to keep her phones, even if they do plan to shop for a grand jury that would actually indict. This is pure harassment. Then she said, nothing in this motion provides any explanation why they would need her passcodes or physical access to her phones. The proposed taint team's review is of the data, the digital files. I repeat, harassment. And then she said, the search warrant arose from Turtle Boy's cases, so it doesn't necessarily bode anything about a new effort to indict Karen. But actually, this search warrant is about Karen, so I'm not sure if Andrea got the right search warrant. They have no reason to justify continuing to withhold the phone. They have apparently successfully extracted them, and the motion is largely towards developing a search protocol with appropriate keywords and a taint team. They'll be able to do some search of the phones based on the original probable cause and the rent in the affidavit, but the scope of the search will need to be determined. However, with no explanation at all, a request to order Karen to turn over her passcodes for physical access to the phones is dropped in the middle. Physically accessing the phone is forensically unsound, as multiple of the state's own experts testified in Karen's trial, most notably Jessica Hyde. No explanation or justification is given either for retaining her physical phones since they have the extractions, or for what possible reason they would need to manually enter the phone. Also unexplained is why it's taking 20 months for the Commonwealth to make this request, since they seized and extracted the phones pursuant to a warrant issued January 2024. And she says, that's pretty much my take on it. And then she said the probable cause itself alleges Karen committed the crimes, but it's based on the same allegations about Turtle Boy's actions that they have used to prosecute him. So it could really be targeting one or the other or both. And so I seem to be in good company here. that Andrea Burkhart agrees with me. And aside from that, Bradle's new motion for Kelsey. Oh, girl, we covered that last week. The motion to reconsider, Nicole? Is that the one you're talking about? The motion to reconsider? New info on Sandra Birchmore, according to the Boston Globe. Let's take a look at this real quick. Remember Robert Devine? Remember Robert Devine, who is pictured with a very young Sandra Birchmore back when she was in the Police Explorers program? Ex-Stoughton police supervisor contacted Sandra Birchmore on the day she died. I'm sorry. What?
Hello.
Hello. Hello, I'm here.
I'm sorry, what? Put it in reader mode so we don't have to deal with the pop-ups. Robert Devine faces disciplinary proceedings in the Sandra Birchmore case. This was published 9/15/25, which is today. Right. Remember, apparently there is DNA of Sandra Birchmore's unborn baby, and it has been reported that it was not Matthew Farwell's baby. The post allegations against Devine include accusations that he had a sexual encounter with Birchmore while he was on duty in December 2020 and falsely claimed that he didn't exchange electronic messages with her. Devine, 53, is defending himself by claiming Birchmore spread false information about him and accusing investigators of bias. The hearing officer, Kenneth J. Fishman, a retired Superior Court judge, heard testimony in June and July, but has yet to render a decision. The Globe obtained redacted recordings of the June proceedings. The Commission's Division of Police Standards wants to ban Devine, who is now a lawyer. He's now a lawyer, because you can't make this up, from working in law enforcement, citing a pattern of untruthfulness, abuse of power, and unprofessional conduct. Attorney Sean Martinez, who represents the commission, revealed during his opening statement that federal prosecutors allege Devine contacted Birchmore on February 1st of 2021, the day Farwell allegedly strangled her during an evening visit to her apartment. Why is this just coming out now when they had an entire extraction of Sandra Birchmore's laptop since February of 2021, the day it was seized, and Garino was in charge of that? Remember, Garino did not find the 32,000 text messages, maybe it was Garino, maybe not, between Matthew Farwell and Sandra Birchmore. And then remember, wasn't it Fanning who met with Matthew Farwell in a parking lot somewhere, took a statement from him and was like, yeah, no worries. You're good, bro. You're good. You're cleared. And they quickly ruled it a suicide. Now it's coming out in 2025. Robert Devine, Stoughton police officer who also had a relationship with her, contacted her the day that she was murdered. No other details about the communication were included in the redacted recordings. Attorney Robert Stowe, who represents Devine, said during the hearing that the case against his client is a big lie. State authorities initially ruled Birchmore killed herself. Federal prosecutors allege Farwell killed Birchmore to cover up a sexual relationship they had been having that began when she was a minor. Oh, yes, he took her virginity when she was 15, and it was in the messages in Sandra's computer. It was all there. was all there. But, nobody ever looked at Farwell as a suspect until the feds got involved in the Karen Reed investigation of the John O'Keefe investigation. And then finally, Matthew Farwell was arrested and charged with murder. And he still sits in the federal system waiting for his trial. And everything keeps getting pushed and pushed and adjourned and adjourned. I don't even know if there's been a conference on Farwell yet in federal court. He has pleaded not guilty and is the only person to face criminal charges. A pretrial conference is scheduled for next month. Birchmore met Farwell and his twin brother, William, through the Stoughton Police Explorers program, which she joined at age 12. The Farwells also had participated in the program under Divine's leadership when they were teenagers, and Divine later enlisted them as volunteer instructors. A lawsuit brought by Birchmore's estate alleges Divine and William Farwell had sexual contact with her when she was an adult. Isn't that nice? The twin brothers passing her around. I'm going to vomit. There he is, Matty Farwell, former Stoughton police detective. Divine denies the accusations. He retired from the Stoughton force in 2022 during an internal investigation into his interactions with Birchmore and is no longer certified to work in law enforcement. So he went out and became a lawyer. The investigating officer is trying to present a lie that has been perpetrated by Birchmore at the behest or the encouragement of William Farwell, Stowe said during the June 5th hearing. The lie is there. It's glaring, but nobody's seen it. Well, okay, what's the lie? Who's the baby daddy? Stowe didn't elaborate on that assertion in footage included in the redacted recordings. Attorney Stephen Marullo, who represents Birchmore's estate, said the claim doesn't make sense and hasn't been raised in the civil case. William Farwell entered into an agreement last September with the commission to relinquish his law enforcement certification. The agency had alleged he exchanged sexually graphic text messages and videos with Birchmore between April and December of 2020. Records show he didn't respond to a request for comment. That's the twin brother, William Farwell. And remember Sandra Birchmore, 2021, and apparently the twin brother was also communicating with her. Who is the daddy? Stoughton Police Chief Donna McNamara and her former deputy, Brian Holmes, were the only witnesses to testify during Divine's proceedings in June. Holmes, who is now police chief in Kingston, led a Stoughton Police Internal Affairs investigation concerning Birchmore. The investigation found that Divine used the alias Marty Riggs, a character in the Lethal Weapon franchise, to communicate with Birchmore on Facebook, which he disputes. As part of his defense, Divine provided internal investigators with documentation showing he's been targeted by hackers, Stowe said. During the hearing, Stowe questioned Holmes and McNamara about their relationships with Divine. Stowe also inquired about an incident during which Holmes retrieved a note written in crayon from his department mailbox, which said, "Revenge is a meal best served cold." The testimony linked the note to a 2016 visit to the police station by Divine's 8-year-old daughter who was using crayons. The girl's visit occurred soon after Divine had returned to duty following his demotion from deputy chief to patrol officer and a 60-day unpaid suspension. The sanctions were triggered by an internal affairs investigation, which found Divine directed a subordinate to look into harassing messages he was receiving as he attempted to end an extramarital affair. In that case, Divine also claimed he was targeted by hackers. McNamara testified she directed a lieutenant to investigate the note. Do you recall that his 8-year-old daughter was given a trespass notice saying she couldn't come near the police station? Stowe asked McNamara. She said that the girl wasn't allowed in the station without my authorization. During Holmes's testimony, he said he and Divine had been friends earlier in their careers, but he distanced himself from Divine in about 2011. He gave several reasons for his decision, including concerns that Divine's interactions with an adult who previously participated in the Explorers program We're getting way too cozy. Yeah, I guess that's Sandra Birchmore. Holmes, unless there's another girl from the Police Explorers program that he was getting too cozy with, which also is quite possible. Holmes testified that he wasn't biased against Devine, but anticipated that Devine would make that allegation and recused himself from interviewing him during the internal affairs probe. Also, according to testimony, an examination of Birchmore's electronic communications revealed Devine's reaction to her raising the possibility that Matthew Farwell had fathered her unborn child. The response was something along the lines of, "You shouldn't be talking to me about this. You shouldn't be talking to anybody about this," Holmes testified. DNA testing has excluded Matthew Farwell as the father of Birchmore's unborn baby, and it's unclear if authorities have made a determination about paternity. Post was established in 2020 amid a state police reform effort that followed the killing of George Floyd by a police officer in Minneapolis that certifies officers, investigates misconduct, sets training standards. Law enforcement officers in Massachusetts must be certified by the commission to work. Fishman, the hearing officer, closed the proceedings, but later authorized the release of recordings. The Globe obtained the redacted recordings of the June proceedings from attorney Howard Friedman, a civil rights lawyer who got them through a public records request. The Globe requested a copy in July, but the commission has yet to produce them. Well, you can never tell. Sunny side of the street is dark. Name that tune. Storm Dancer. So easy for them to say Birchmore said or did anything now that she's not here to defend herself. Yeah, 100%. Thank you for your super chat, Storm Dancer. Hey, it's May. Thanks for your 20. I don't understand how Massachusetts doesn't have a speedy trial law. Isn't it laid out in federal law? Yeah, but the states are not required to follow every bit of federal law. And so the states have an option. Betterow explains it far better than I can. And so I'm not going to attempt to explain it to you, but he says there's no speedy trial statute. In federal law, for federal trials, yes, there is one. And that's why. Hang on. They don't have it. They don't have protection for journalists either. They don't have protection for, apparently the First Amendment goes there to die, and they do a lot of things differently than a lot of other states. You're not allowed to state your objections and all kinds of other really weird things and procedures. But as you know, the states are granted certain powers of things to determine for themselves, and that is one of them that they have chosen not to follow. Thank you for your super chat. Rhiannon, do they have correct DNA for the paternity test? I don't know. I don't know. I guess that crossed over. We don't know. And by now, Farwell has to have waived speedy trial. I agree. I don't know. But I mean, you know that the DNA of Devine and all of them aren't they on file for exclusion purposes? Or do they destroy their DNA samples if they get, like during Karen Reed's trial, they got the DNA of Proctor and I guess Buchanan. They did swabs of them to exclude them from the things found on the car, like the DNA and the touch DNA. No, not Ship of Fools, Shakedown Street. That's Shakedown Street. Somebody probably got it, but I wasn't watching the chat. And Ms. Mojo Horizon says maybe Farwell did for his buddy Sickos. Thank you for your super chat, Ms. Mojo Horizon. All right, I need to take a break because it's 1:24. We're going to come back at 1:50 to cover the Brian Walshe Miles King hearing. When I end this stream, it's going to teleport you over there so that you can get right in and be ready. And we can see what the hell is going on with, as such, the Brian Walshe Miles King case. So if you would do me the great honor and pleasure and courtesy of just smashing the like button on your way out if you haven't done so already. Thank you to the moderators for keeping it classy. And when I hit buckle your seatbelts, because when I teleport you over, you're going to be teleported right over to the 2:00 stream. Go take a break, get your popcorn, get your drinks. You have about, 25 minutes or so. All right. They take them, then they destroy them. That's what I thought. All right. Thank you so much. Love you guys with all of my heart. But I'm going to see you real soon. In fact, in about 25 minutes. Peace.